Thank you. Thank you. Thank you. Okay, order. Good afternoon, ladies and gentlemen. My name is Laban Erwasa. I'm the Registrar School of Law and at the same time, the Secretary of the Examination Panel for this public defense for Mr. Oscar Kambona. I warmly welcome you to this Doctor of Law Public Defense, and I want to thank you for joining us as we examine and celebrate this important contribution to the legal scholarship. Chair, I'm happy to report to you that as per the Mackay University guidelines, that is to be in specific, the graduate handbook, we have met all the standards and the requirements that permit to constitute and hold and have this public defense take on. I report to you that the public is being well represented. The doctoral committee members are present. The examination committee is well constituted, briefed, and empowered. The candidate himself is in presence, and we're just good to go. With those few words for noting for the Secretariat, allow me welcome the chair to start off the public defense. Thank you very much.
Members of university management, professors, and members of faculty and staff of Mackay University, our panelists this afternoon, members of staff from sister institutions, invited guests from government agencies, and institutions working in the thematic area of our area of research today. You are carefully selected, and I can see representation from several institutions. Thank you very much for coming. Your presence adds to the academic rigor of this process. Students from Mackay University and from sister institutions, ladies and gentlemen, and of course, our doctoral candidates. Good afternoon. Welcome to the School of Law, Mackay University, the leading and premier school of law in Uganda and south of the Sahara. My name is Zahara Nampeo. I'm the Deputy Dean. I bring you greetings from the Dean, who is unable to join us because he's away on other official duties. Welcome to this doctoral defense. Your presence plays a crucial role in disseminating information, knowledge generated through the research of this defense. We are going to be discussing knowledge which we hope is relevant, not only for academic purposes, but also for policy, for industry, for the legal sector, other sectors, as well as Uganda's development agenda generally. And we are also here to witness the formal certification or otherwise of a new doctor of law. And yes, some of you are also here for provision of social and professional support. So let us be kind. This is the third doctoral defense this academic year at the School of Law. In the past, we have not had many lawyers doing PhDs, but this is slowly changing. The interest is growing. We have a docket of about 42 right now, and we hope that many more will join. Perhaps this is justifiable, a journey where supervisors and doctoral advisors seem more like adversaries, and supervision meetings become like emotional marathons. And sometimes the candidate is asked, choose thesis or sleep. Let us give a hand clap to our doctoral candidate who has taken this big step. What is a public defense? At Makerere, we do our Doctor of Laws degree by research. In some units here at Makerere, we do taught doctorates, but ours is a research. So the thesis that is going to be presented is a focused piece of research that is performed to obtain an LLD, a Doctor of Laws. Our engagement this afternoon is a public examination of this thesis. Mr. Kambona's thesis has been examined both internally in Makerere University as well as externally from faculty outside of Makerere University, and he passed. That is why he's here. This engagement, therefore, is to examine the extent to which he is familiar with his field of study and the ability to critically analyze the relevant literature and trends, his mastery of the methodology, and whether he makes an original contribution and advances knowledge in his field. I know that, Oscar, when you have written your work too many times, it starts to have an identity crisis. It's neither here nor there. But I believe that by the time you're here, your work is here. It is not there. And I know that if you're here today, this afternoon, you're halfway there. So today at the Public Defense, allow me to introduce his supervisors this afternoon, Professor David Justin Bachibinga. And Professor Christopher Mbazira is in Lulongwe, Malawi, advising the judiciary that side. I think maybe he might be coming soon to support the one this side. Let me also introduce our panelists this afternoon, very carefully selected for their expertise and practice in this area. Dr. Ismail Chintu, who is waving at you, is a lecturer in taxation management and public financial management at Makerere University at the College of Business and Management Sciences, teaching both undergraduate and postgraduate levels. In addition to his teaching responsibilities, he has conducted numerous tax-related research studies, including the impact of digital tax stamps on revenue mobilization, and also a comprehensive analysis of the gender and equity responsiveness of tax policies. Thank you, Dr. Ismail, for joining us. Mr. Festus Akunobera is a Ugandan lawyer practicing tax law, recognized as a highly regarded lawyer by the Chambers and Partners Global and IFLR 1000. He graduated with a first-class Bachelor of Laws from Makerere University. You know what that means. He holds a Master of Laws in International Taxation from New York University and has served as a guest lecturer here at Makerere, as well as in other reputable global institutions like Duke University and Vienna University of Economics and Business Administration. He's a co-founder of the East African School of Taxation, where he was CEO and lecturer for over 10 years, and is currently also co-founder and tax partner at Abmac Associates. He was called as an expert witness on Ugandan tax law in the London Commercial Court. Welcome, Festus. Dr. Hilda Topaku is an advocate of the courts of Uganda, holding a degree of Doctor of Philosophy from the University of Witwatersrand with a focus on international trade law and regional integration. Dr. Topaku has worked both at private and public sector with institutions such as the University of Fort Hare and Uganda Matters University, teaching and conducting research on the law of banking, copyrights, taxation, and taxation and trade under the WTO. She's currently at the heart of the research unit at the Law Development Center. And lastly, last but certainly not least, is Dr. Dan Ngabirano, who is also our critical discussant, also known as opponent. A lecturer of tax law and policy at the School of Law, Makerere University. He has researched and published on several aspects of taxation, and most recently authored a working paper on the experience of Uganda in the implementation of international tax standards on behalf of the International Center for Tax and Development. He holds a Doctor of Juridical Science from the University of Iowa in the US, a Master of Laws degree from Harvard University, and a Bachelor of Laws degree from Makerere University. He is an advocate of the courts of judicature and member of the Uganda Law Society and the East African Law Society. Thank you very much, Dan. Colleagues, you may have glimpsed at the book, the thesis, 300 and something pages. It has been about 3 or 4 weeks of hectic reading for the panel. So thank you very much for making the time. And thank you very much, ladies and gentlemen, for also being here with us today. Oscar, you did not know your panel, but now you know who they are. That was one of the best kept secrets. The session is being live streamed, and we are also joined by an online audience, perhaps also some family members. Any family members here? Yay! And any online family members, please send flowers. They say that every PhD is 1% inspiration and 99% panic. Mr. Kambona, come and show us that panic. Oscar, it is exactly 2:30. You have 30 minutes.
Thank you very much, Deputy Dean and Chair of the panel, panelists, professors and lecturers, ladies and gentlemen. Sometime in 2012, I was arrested, detained, and tortured by the URA. My personal items and properties were taken, my home raided, household items and goods stored at my home confiscated on the allegation of violation of tax laws. It was alleged by the URA that I had smuggled an unspecified number of used electronics, which were still under customs control at Ken Fright ICD. I was taken to the URA headquarters and made to record a statement. In the process, they went to my brother's premises, arrested him, removed clothes from him, and took him before his garage where some goods had been stored. He was then paraded before his children, despite his pleas. Ladies and gentlemen, that is an extract of testimony in a civil case in the High Court of Uganda, civil suit number 93 of 2014. Paulo Baguma versus URA. The court believed that story and found the URA to have been in breach and violated his right to lack of torture and equal treatment. In that story, two aspects arise. On the one hand, you have powers of the URA. What they were doing in going to the property and confiscating was in fulfillment of powers granted to them by law. On the other hand, you had Paul Baguma, who had his rights as a citizen of Uganda, rights provided for in the Constitution and in several laws of Uganda. That informs part of the discussion we are going to have this afternoon. An analysis of the powers of the Uganda Revenue Authority in relation to the taxpayers' rights to property and privacy in Uganda. So this presentation is going to follow as follows. I will have an introduction. I will then state the problem, the objectives of the study, the theoretical framework that was used to undertake the study, the methodology that was used to undertake the study, and then I will have findings of the study. And then summary of conclusions and recommendations. And second but not least, a relevance of the study and areas for further research. The link, ladies and gentlemen, between taxation and state building is well documented. Governments need finance to run its operations, finance to provide services. And that finance can either be through revenue from taxation, or it can be from loans, both local and international, or it can be grants. But of all those sources, the most reliable and most crucial is taxation. Therefore, taxation is at the center of the state. Beyond taxation being relevant for economic development and the running of the state, taxation is increasingly becoming relevant as far as realization of human rights are concerned. We have seen a story of Paul Baguma. We have seen issues of his rights. Taxation is becoming central, not only because taxation provides resources that give certain rights like health and education, but also it enables the government to provide a framework through which other rights like fair hearing and some of these civil and political rights are respected and adhered to. Taxation in Uganda, ladies and gentlemen, is shaped by the country's history. Over periods of time, since pre-colonial, colonial, and post-colonial, governments have had agendas that have shaped how taxes are collected. So the power to levy taxes in Uganda, first and foremost, is derived from the Constitution, which under Article 17G provides that it is an obligation of every citizen to pay taxes. Having said that, it is also constitutionally provided that there will be a Bill of Rights. So, as we analyze this topic this afternoon, the question we may ask ourselves is, why did I choose these two particular rights? Why did I choose privacy? Why did I choose property? The two are always interlinked. In most cases, taxation by its very nature is a deprivation of property, because the money that is being taken is my money, but I'm being told, give 30% of that to the government. So one of the rights that is likely to be infringed is property. But as we shall see, there are certain parameters under which it can be done. But in most cases, By the time they come to interfere with your property, they have trespassed on you, either your privacy as an individual or your premises or your correspondences. So these two became very critical, and that's why the two were analyzed. Now, we may ask, so where's the problem? Where's the problem? You have taxes, yes. You have rights, yes. Where's the problem? Taxation in Uganda falls under two categories. Especially, and I want to mention this afternoon, we are focusing on compliance. People being able to pay their taxes. We are not so much focused on the assessment, how much tax someone has got to pay, when it's supposed to pay. We are focused on compliance. So, taxation in Uganda either falls under voluntary or involuntary. Voluntary is you earn your income, you raise your assessment, your return, you determine how much you're supposed to pay, you go and get a bank advice form, pay the tax, end of matter. But they are not everybody will do that. There will be those who will not comply. And it is those that will not comply that require some intervention and enforcement from the URA. To be able to do that, the URA has been granted certain powers to help them in the enforcement process. So, these enforcement powers are supposed to be a last resort. They are not supposed to be the first resort. Now, despite these powers, compliance remains low. As we shall see, Uganda is among the least in terms of compliance when you undertake what we call a tax to GDP ratio. Currently, we are standing at 13.9% of our GDP. Our neighbors, our peers, some of them like Kenya, which is one of the comparative countries, stands at about 16 to 18%. South Africa, which is on the same continent, has a tax to GDP ratio of 28%. So there is a problem. There is a problem of compliance. We have everything, but the problem is of compliance. So the point is that despite these powers, compliance remains low. Now, in the process of enforcing these powers, it is apparent that some of these powers are likely to infringe some of these rights. Remember the case of Baguma I started with. You can ask yourself, was there an infringement or not? And that's what we shall be looking at. Now, that aspect needs to be investigated. Now, so what's the objective? The objective of the study is to investigate the nature and extent of the URA's processes of enforcement of taxes and how that impacts on the rights to property and privacy during, and I must emphasize, the collection process. Now, this main objective is achieved using sub-objectives. The first objective is to examine the legal and institutional framework for collection of taxes. Second is to examine the international and domestic framework for protection of property, the right to property and privacy. The third objective is to examine the nature and extent of infringement of these rights of property and infringement during the collection of taxes. Then fourth is to carry out a comparative analysis of how rights of taxpayers are viewed and protected during the enforcement of taxes in Kenya and South Africa, two countries which I will explain why I chose the two countries. And then finally, to make recommendations for reform of the tax laws in regard of protection of rights. Quickly, to be able to answer this objective, there are certain questions that I had to come up. Central among the question was how the rights of taxpayers, particularly the rights to privacy and property, are affected by officers of the URA in the excise of enforcement powers under the law. Now, there are specific questions that are derived from the specific objectives. Quickly, why was it necessary to do this study? Why is it necessary to investigate the exercise of the powers vis-a-vis the rights? First and foremost, there is a need, as we have seen, to balance between the powers of the URA and the taxpayers' rights. Like I mentioned, both the powers are in law and both the rights are in law. So the question is, how do you strike a balance? And it is what we are trying to investigate in this study. Second, the intention is to make proposal for reforms on the checks and balances. We appreciate the value of checks and balances in a system, and so we will be making some recommendations for reform at the end of the presentation. I mentioned in my introduction that Uganda is doing badly when compared to some countries like Kenya and South Africa in terms of tax to GDP ratio in sub-Saharan Africa. So this study was to help in the generation of knowledge that can help increase compliance and ultimately revenue mobilization. So the study is premised on the theory, on the understanding that respect for taxpayer rights increases tax compliance and hence increased revenue. Before this study was conducted, it was important to realize that we are not replicating something that has already been researched. We are trying to produce something that is important and is relevant to the society. So a literature review was conducted. Now, most of the literature that has been written on taxation is with regard to development. How does taxation bring about development? But some literature more has also been written about human rights and taxation. Human rights and taxation. However, there is a qualification. Most of the literature is on human rights and how taxation helps in realizing these rights. This study is on the other side. This study is saying human rights and taxation, but how the enforcement should respect and promote the rights. So there is a gap. There is a gap of violation of rights during the enforcement process. To be able to undertake this study, a methodology was conducted. So we used the methodology to conduct this study. This was a purely qualitative study. Qualitative in the sense that we are trying to understand behavior. We are trying to understand motivation. What is motivating people to pay their taxes? What is the lived experience of these people? And that's why it was a qualitative study. And the philosophy, the research philosophy is what we call interpretivism, trying to interpret the circumstances to try and find meaning from what you are interpreting. So the research design, as I mentioned, has an element of comparative study. We are trying to look at other countries and how we can learn and benefit from those other countries. But also, there's an element of descriptive and analytical, trying to describe and analyze some of the data that was received. The study population was mainly taxpayers, both medium, small, and large taxpayers. Also had the enforcement agencies, the URA, the Ministry of Finance, which is the parent ministry for the URA, and then the Tax Appeals Tribunal, to mention but a few, where most disputes are actually channeled. It also included professionals, tax consultants, tax lawyers, many of you who are here in the audience this afternoon, but also the private sector and the civil society organization. So the main data collection tool were key informant interviews And these key informant interviews were open-ended questions, trying to solicit as much information as we could from the key informants. Finally, in terms of sampling, how were they chosen? There were few, there were 20, but they were chosen through what we call purposive sampling. Because qualitative studies are not supposed to deal with data numbers. It is what is represented from this, the sample that you have chosen. But an endeavor was made to make it as broad as possible. Quickly, the theoretical framework, there were theories that were used. To be able to understand a scholarly study like this one, you have got to use certain theories, and I used 3 theories. The first theory is the social contract theory. The second theory is the human rights-based approach. And the third theory is the human rights-based approach of fiscal sociology. Quickly, the social contract theory, very important contract theory when it comes to taxation and compliance. Taxation is a product of an agreement that has been entered between citizens and the government. The citizens agree that they will release part of their property, and that property shall be used to run government, and that government shall in turn provide services to the people. Central to the social contract theory is consent. The consent of the people is very, very critical. Quickly, the human rights-based approach is purely everything that you do, the outcome is as important as the process. That's what the human rights-based approach is all about. That if you want to collect taxes, you want to bring in a lot of income, how you collect that income is very important. And it therefore recommends 3 things. 1, you must respect. 2, you must protect. And 3, you must fulfill the rights. Briefly, the human rights-based approach to fiscal sociology is almost more or less linked, because it looks at the lens through human rights, trying to understand the taxation within the context of the society. But more importantly, it introduces what we call fiscal legitimacy. That is how the citizens look at taxation as either it's being fair. So at the end of the day, these 3 are aimed at emphasizing 1, transparency, 2, participation, and 3, accountability. Now, quickly, the findings. Having done the study, what were the findings? And the first one is the examination of the legal and institutional framework for collection of taxes in Uganda. The examination of the legal and institutional framework of collection of taxes in Uganda. To be able to understand this particular objective, it was important to go back and trace the historical origin of taxes. Did we have taxes in Uganda? If we had taxes, what was taking place? But mindful of the fact that we are only looking at the enforcement process. So, in pre-colonial era, there were taxes. Uganda had taxes. People were collecting taxes, but these were collected by the chiefs. The chiefs who would then pass over, in, for example, Uganda, pass over the man to the Kabaka. But one critical thing about collection of these taxes is that there was uniformity. Taxes were being collected, and in most cases, the Abakopi, what for example were called the Abakopi, were more or less paying the same amount with the chiefs. But it was in form of, in kind, in backcloth, cowrie shells, sometimes in provision of labor. And there was an understanding where you would be allowed to pay your taxes in installments. Come the colonialists in 1894, they then introduced a cash tax system. They now demanded cash. And the idea was that if you didn't have cash, you would have to go and work and then produce money and come back and pay tax. But there was something critical about the colonial era. There was segregation. discrimination. The natives were paying, whereas the non-natives were actually not paying tax. And that is something that ultimately brought about resistance of taxes. In particular, during the colonial period, there was hat tax and poll tax. This poll tax subsequently is seen in what we eventually got to know as graduated tax. So, ultimately what happened is that there ended up being a revolt. There were revolts against taxation in Uganda during the colonial period, and these revolts distanced the natives from taxes. The post-colonial tax reforms then included Uganda. By then, after independence, had actually joined together with Kenya and Tanzania to form the East African community, and they had similar centralized tax. So collection was purely centralized and legislated for in these various laws. The current position is that, and I'm talking about specifically income tax, this is what the study looks at. In 1974, there was a law passed as the Income Tax Decree, which was subsequently repealed in 1997, and that law from 1997 is still in force to date. But that law has been amended from time to time. Quickly, there are policies that government has put in place to try and improve the way taxes are collected, and some of them include the domestic revenue mobilization strategy. I reviewed both the strategy number 3 and strategy number 4, which started this financial year. And then, of course, Vision 2040, you've all heard of how government's plan is to increase the economy by tenfold, from 50 billion to 500 billion by 2040. So that was also reviewed. And then finally, the 4th National Development Plan. Quickly, the finding was that the legal and institutional framework or collection of taxes are not human rights compliant, hence prone to violation. And secondly, we were able to discover that there are substantial powers and discretions, especially during tax collection, which are prone to abuse. Ladies and gentlemen, we have I have to rush through this. The international and domestic framework. Again, there is existing legal framework both at the international level and at the local domestic level. Importantly, human rights started gaining prominence since 1948 with the Universal Declaration of Human Rights, and we see that some of these other subsequent conventions also provide for right of privacy and property. The Constitution of Uganda under the domestic, under Article 26 and Article 27 provide for the right to property and privacy. However, as we shall see, there is a limitation. Those rights are not absolute. Those rights can be limited, and that is under Article 43 of the Constitution. So the finding, and of course there are specific laws, the Computer Misuse Act and the Data Protection and Privacy Act. So the finding really was that the existing legal framework is not adequate enough in protecting rights, these particular rights, as we did, as we shall mention shortly in research objective number 3. Now, quickly, research objective number 3 was to look at the nature and extent of infringement. And the finding in non-infringement terms was that yes, there is some infringement. There are some infringement of these rights. One of the powers, again, we reviewed 7 powers. One was issuance of agency notices. URA has got a power to issue an agency notice on your bank and collect money if there is an assessment that remains unpaid. One of the problems we discovered during the study is that actually some of these agency notices are issued when the tax is in dispute. I am contesting the tax. You are going to my account. You're taking my money from my account. We are still in court. You are infringing my rights. Again, that is one of the areas that was looked at. We also found that sometimes notices are issued at the same time as the assessment is being issued. despite the fact that you have got 28 days within which to pay taxes. Quickly, we also looked at distress proceedings. The URA has got a power to touch your property and sell it if there is no payment of tax in time. The other power that we reviewed is the 30%. The URA, under the law, you are supposed to pay 30% of your tax in dispute before you go to court. And the question is that deprivation of property? I am disputing the amount, you are taking the amount. This has been a subject of constitutional debate with two leading decisions which seem to say, one, the Upmark case, which says it's okay, it's legal, there's nothing unconstitutional. But you also have the FuelX case, which came up and said, no, if there is no figure involved, then there is it is an infringement of rights. Quickly, we have got temporary closure of business. The URA has got a power to come and close your business and put a notice closed because of lack of taxes. Remember, I'm supposed to pay tax. You're closing my business. My business is closed. But there has been some infringement in terms of time because the law says you can only close for a maximum of 14 days. But sometimes, as we shall see in some cases, URA has closed them for quite a longer period. In the case of one Solutions versus URA, which was in a tax appeals tribunal, the premises were closed for 5 months, and we found that to be an infringement. Now,
Quickly,
yes. So quickly,
you have used up your time.
yes.
Yes, but you can take some 10 more minutes.
Thank you. Thank you. So quickly, access premises. URA is entitled to access premises, records, and storage devices. There is also an issue of data protection and confidentiality. And then there's an issue of information notices. Information notices, URA has got power to write to you, even if you're not a taxpayer, to ask you to provide information about a taxpayer. 2 instances have happened. They wrote to the banks saying, we want information about all your customers. That was challenged in court, and the court set it aside. They also wrote to National Water and Sewage Corporation asking them for records about tenants. Again, we found that to a certain extent, that has been a violation. Quickly, the comparative study, I have displayed a graph which shows what happens in Kenya and Uganda. So Uganda and South Africa. I want you to look at the second last line. It shows that tax to GDP ratio in Uganda is 13.8%. In Kenya, it is between 15.2 to 18%. And in South Africa, it's 26 to 28%. Clearly, we are doing badly. We are lagging behind. However, the most important thing is that, yes, there are certain things that we can learn from these two countries, but central upon them is the fact that there is a lot of judicial intervention. Whereas URA or in Uganda, URA can go on premises without a warrant. In South Africa, you need a warrant before you go to the premises. Now, as I conclude, what are the recommendations? Quickly, the first and core recommendation is that we need to introduce what we call a tax ombudsman. An ombudsman is like an IGG. We are honored to have the IGG here today. You have an IGG, but this time focused on tax. And what the ombudsman will strictly be doing is to say to what extent are complaints of service nature. It is not taking away work from the courts or the tax appeals tribunal. No, it is dealing with service related. You may find a situation where somebody has done something wrong or there has been a delay, but there's no decision. So in this case, the ombudsman would intervene and recommend remedial action. Quickly, we need public participation. We need the public to get involved in taxation. We need an enforceable taxpayer service charter. Currently, the charter is not enforceable. It's just a statement of intent. But then we need, like we said, in Kenya and Tanzania, there's a lot of judicial oversight. So we need enhanced judicial oversight. We need increased use of modern technology. We need to enhance tax morale through accountability, and we need to boost taxpayer awareness and tax education. But more importantly also, we need to educate the enforcement agency staff. As we shall see, it's very, very important that they are doing something, but they also need to be updated on some of these things. And then finally, to minimize compliance costs. Conclusion. The first conclusion is that despite the existence of these powers aimed at maximizing compliance, URA has not been able to raise the tax to GDP ratio to its recommended and target, which is supposed to be about 18 to 20%. And this remains very low. Secondly, we established during the study that there has been infringement of taxpayer rights. And as we shall see, as we saw, there are different aspects under which the rights were infringed. However, the study was able to demonstrate the shortcomings of the prevailing legal and institutional framework. Ultimately, there has been a downward trend in the overall enforcement measures. However, and I want to emphasize this, there is a general improvement by URA in observing service standards. I believe in giving credit where credit is due. We are not yet there, but URA is trying its best to get there. And as we saw in the first case, some of those cases were in 2012, but there has been an improvement, and we are seeing a general improvement from the study that we conducted. So there is need to balance the competing interests. You want to increase revenue, but at the same time, you want to protect the rights. And then second last is that the legal and institutional framework for collection of taxes are not human rights compliant. That is a key finding that cuts across this study. And finally, the need for judicial intervention. The need to involve the judiciary as an independent arbiter. You have the taxpayer who may have his bias, who may have his interest. You have the URA, which has got its bias, it has got its interest. How do you bridge that two competing interests? You need an neutral arbiter, and that neutral arbiter is the judiciary. Thank you very much.
Evidence of years of intensive study. What I am not sure of is whether, Oscar, you hired some mercenaries to come and clap, because the clap is very heavy. Yeah, mercenaries is not an uncommon phenomenon, especially in this election season. Anyway, that said, thank you very much, Oscar, for that articulate presentation. You are able to save 4 minutes. I invite you now to drink some water and now engage with your critical discussant. Would you now, Dr. Dan Gabirano, as the opponent appointed by the Research and Graduate Training Committee of the School of Law, present your comments and engage the candidate on his thesis. Is it his thesis? Over to you, Dr. Dan.
Thank you very much, Chair. It's a privilege and honor to be able to serve as a critical discussant, stroke opponent for this very interesting and important study. I want to start by congratulating Oscar for coming this far. To put together a thesis of this nature is by no means a simple task, but also as a personal friend to congratulate him. However, today we shall not necessarily be very good friends. We shall proceed under the arm's length principle, which means in taxation that we are to deal as if we are unknown to each other, given my role. So having said that, I want to start with what I thought were the key strengths
from this thesis. First, I find that it represents what I've come across so far as one of the most comprehensive scholarly studies of particularly, the tensions between taxpayers' rights to property and privacy and tax enforcement. There's been a lot of talk around this, but interestingly, there's not been much scholarly attention in that respect. But even then, the talk, which is largely been, in the streets about the harshness of URA, but also in the courts, in the cases highlighted, UPMAC, FuelX, has largely centered around the procedural aspects, procedural human rights aspects as they relate to taxation. I've rarely come across a study that looks at substantive rights, in this case, property and privacy. So most of what we've seen is been around how some of these enforcement measures restrict the enjoyment of, the right to a fair hearing, access to court, especially the 30% requirement. But we have not quite seen, both in terms of scholarly work and litigation, much attempt in linking the substantive rights highlighted here to, enforcement and compliance. Which takes me to the next observation, the looking at taxation in the context of citizenship. Many times we tend to focus on taxation from purely a fiscal point of view, but this is, a study grounded in more of citizenship, by virtue of the social contract, which is that, agreement between me and the state. I should expect some respect for my rights in return for me ceding some of my rights, including property and privacy, as we shall see. So that I thought was also something positive here. The case studies used are quite strong, Kenya and South Africa, both in terms of context, but also inspiration. In terms of both human rights, the South African Constitution is one of the most progressive, and Kenya recently enacted quite an interesting, Bill of Rights. But also in terms of domestic revenue mobilization, that these are countries that you'd want to, emulate. But also the study demystifies what has become a long-term thinking. When people talk human rights, you think about the most vulnerable. But here is an issue of human rights that affects, small taxpayers, almost in the same measure as the corporates or large taxpayers. You've heard of the case of Paulo Baguma, but also you'll find cases of Airtel, you'll find cases of, Vivo Energy, all concerned about some of these, URA enforcement measures, which really goes to, and I think it's a big, it's quite an interesting point for me because, many times we look at human rights just for the vulnerable, but in taxation, the rich also cry. In the Airtel cases, Vivo Energy, they're also crying about the 30%. And to me, that is critical, especially where increasingly you have human rights being relegated to the periphery, many times saying, human rights are useless. But, this goes to show you that actually human rights are critical, even in an area like taxation, but also, for meaningful development. Okay, so having said that, now I go into some of the questions arising from the thesis. So Oscar, this is where you have to put on your guard and I have to grab a squad so that we can have that intellectual conversation. Okay, so for me, I'll start with the fundamental point, and I was quite curious that in this you actually don't define what a tax is, and I think that's quite critical. You start largely with stressing the importance of taxation, but you don't tell us what a tax is. And I think this really goes to the ground, to the very foundation of the arguments that you seek to make. So that would be my first question. How would you define a tax?
Thank you very much, Dr. Ngabirano. Context. We agree that taxes are paid by the subjects to the state. So basically, it is a transfer of funds from the private to the public. But in simple terms, if I were to say, it is a compulsory levy. And I think for me, that's very important. The emphasis of compulsory, because you cannot opt out. You cannot choose. So it's a compulsory levy that is imposed by the state under the law to raise revenue for purposes of running the government.
Thank you very much. And that's very critical for me. I just took a look at the URA tax curriculum, and they define a tax as a non-quid pro quo payment made to a government as a charge for the cost of administering services to the public. You don't expect anything in return. It's compulsory. You cannot opt out. And that is fundamental. Now, and encompasses many other things there. One, of course, is that there is a clear sovereign right of a state to tax its subjects, right? But that taxation makes states, and actually states may collapse because of taxation, makes states in the sense that you are legitimate to the extent that you're able to tax effectively your citizens. If you cross to, across the border, the DRC, or most recent scenario, the M23, one of their sort of clinches legitimacy is the ability to extract some form of tax. You may have a conversation whether it's illegal or legal, but that gives them legitimacy. So it's a legitimacy tool for states, okay? So now, having looked at taxation as that, how do you then reconcile it with the argument that you seek to make that, URA or the state should exercise restraint in when it comes to tax enforcement, arguing among others that this infringes on rights to property and privacy?
Thank you very much. Again, my emphasis was the word balance. The word balance, because of the recognition that both are important. On the one hand, we all appreciate the need to pay taxes. And as you rightly point, it's a sovereign right of the state. The state has the right to, and it's legal. First, it is constitutional. The Constitution is saying it is a responsibility of every citizen to pay tax. Article 17G. And it goes on to say under Article 152 that no tax shall be enforced unless under a statute of law. That's why all tax. So the fact that we need to pay tax is important. However, should we have development without a human face? Should we have development where people are cursing, people are not happy, there's no legitimacy just because we are interested in taxes? The balance becomes important. How do you achieve the balance is what we have been discussing. Achieve a balance by putting in place checks and balances. put in place checks and balances, put in place an institution like the ombudsman, tax ombudsman. I can hear people asking, but Uganda has been rationalizing institutions, reducing institutions. Now you are recommending another institution. No, and I don't think the issue of rationalizing institutions takes away the need to introduce very important institutions like the tax ombudsman. Because you must have heard at one point, the president had appointed the presidential advisor on revenue. And then there was some changes and he was not confirmed. But the point is that you are looking for a balance. You are looking for a situation where the method of collection of tax in itself has a human face. And that's what the theories of human rights-based approach was emphasizing. So in the short response, the short answer is that yes, balance. You can have a balance where you have the right to tax, but also do it in such a way that you do not infringe the rights.
Okay, thank you. So I just want to still pick up a little bit on that. And I think the last statement to me is what stands out. So you talk about theories and the human rights-based approach. But even to push further, you talk about the social contract.
Yes.
And I think that is maybe the beginning of a basis then to even seek that balance. So you in terms of your theoretical framework, you tend to essentially advance the social contract theory. The idea that there is an understanding between subjects and those who are in power, that we will seize some of these rights, and then in return you protect us, you respect our rights, or something like that. Now the social contract theory is part of the bigger theory of fiscal sociology, which you touch on a little bit, but which is even broader in the sense that you're talking about taxation, you're talking about expenditure, you're talking about institutions. But it's fundamental, it's broad, but somewhat you perhaps you give it just 3 or 4 lines, and yet your argument seems to be very strongly linked to this, because if I understand the argument is where there's respect for these taxpayers' rights, there is voluntary compliance, citizens are more willing,
yes,
right? Which brings into play the other aspect of the fiscal sociology theory, the aspect of revenue bargains, which can be direct or indirect. In this sense, indirect. In light of that, could you perhaps explain why you then dwell so much more on the social contract theory than the broader fiscal sociological theory that, among others, reflects the revenue bargains approach?
Yes. Social contract, in my view, is the foundation of taxation, because it is based on the understanding that before society was there were no structures. All of people in society, there was an element of, if I could use the word, chaos. To be able to have an organized society, to be able to have a society where services are provided, where there is security, where there is respect of my property as opposed to respect of your property, they then come into that understanding. And in that understanding, they say, we shall have our property, but we shall contribute some of it. So the foundation of taxation is on that understanding of free will, out of free will that I am giving. How important is the fiscal sociology? Very important also, Very important, because then it says it is looking at the setting under which the taxes are being collected. It's broadly, and you're right when you say it broadly looks at public finance. And when we talk about public finance, we are talking of things like taxation. We're talking about things like budgeting, the budget. How much of that money is being budgeted for what? If you are giving a huge budget, I'm giving examples. If you are giving a huge budget to Parliament, for example, and you are giving lesser budget to the medical side about it, it's those things that we are looking at in the fiscal sociology theory. Budgeting. But beyond budgeting, debt. You may not collect enough taxes, but you are going on and taking on a lot of taxes. As you've heard of countries like Ghana, Zambia defaulting just because they cannot afford to pay their debt. So issues of debt are also issues of contention under this fiscal sociological theory. But also importantly, expenditure. How is it expended? So yes, I agree. It is a very important, theory which gives that broader, and like I pointed, there is an element of fiscal legitimacy. And you mentioned in your introduction, the willingness to pay, the willingness to comply. That's what I call tax morale. How are taxpayers' tax morale enhanced? People's tax morale is enhanced because tax morale is the intrinsic willingness to pay. How do you increase my intrinsic willingness to pay? Be transparent. How do you increase my intrinsic willingness to pay? Participate. Allow me to participate in the process. Accountable. Be accountable. So it is those, and all that is captured under the fiscal sociology. But like I said, I didn't put much emphasis on the social contract as the foundation of the whole basis to tax. Thank you.
Okay. Moving on to the methodology. So you indicate that you, on average, interviewed 2 officials from each of the main government agencies, this being URA, Ministry of Finance. And then when it came to taxpayers, you had 5 large taxpayers, 3 medium level taxpayers, and 3 small taxpayers. Now, from this, you come with an overwhelming conclusion that the arbitrary enforcement of taxes by the URA, discourages voluntary compliance and with implications for domestic revenue mobilization. My question is, how representative is this sample? This huge pond of taxpayers, you're able to fish just about 11 of them. How representative is that?
I'll answer it in 2 strands. The first strand is those that I looked at, the 20, including the small, medium, and large taxpayers. It was a sample, and the sample was purposive. What do I mean? I was able to identify, for example, in the small taxpayers, those that are likely affected by the enforcement aspects. For example, as you will see, seated traders closed their shops over tax law. These were people in downtown who decide to say, we are not going to accept this. Why? Because we are not happy with the enforcement process. Some of those traders are those small taxpayers are included. They need not cover everybody who went on strike, but they represent the views of the people who went on strike. and therefore they have an opinion on how the enforcement process is problematic. But secondly, the purposive, first of all, the qualitative method, like I said, is targeting to interpret lived experience. What are people going through? What is their lived experience? What is their motivation? What is their behavior? Now, you can get that and cut across and say, among these traders, if this is the trend, then it can be representative of and show you a direction. But I want to also mention something. Most of the tax disputes have either ended up in the tax appeals tribunal or have ended up in the courts of law. An example is the case of Paulo Baguma I started with. There are other cases that I quote in my Uganda Revenue Authority goes to the premises of Yoyo, confiscates computers, but includes a phone of an individual managing director. The managing director has his photos on that phone. You must have had the Ebola case in Guinea. You've got my private information. So how now it's those issues that in supplementation to the 20, there was a wealth of case law that I reviewed that actually confirms and correlates the key informant interviews.
Okay. Well, we can go with that. That you mentioned that you were able to then essentially look at court cases and come to that conclusion. But I'll probably come back to this later. Now, turning to the literature, which is a very critical piece of a thesis of this nature, in the sense that that is where we are able to see your contribution to scholarship. You tend to focus a lot on, literature around tax reforms, a critique of the human rights, taxation literature, to the extent that it focuses more on the developmental sort of role of taxation and human rights and less on the substantive rights. But, again, going back to the fact that your arguments are largely anchored in the broader fiscal sociology theory. Did you come across some literature that may support your work in that sense, that perhaps you could point us to, just to again understand how your work is anchored in the broad, theories and literature, yes, but also importantly, what your contribution is.
I'll start with literature on human rights and taxation. Our very own Dr. Humuza Diana, who is fortunately with us this afternoon, wrote extensively, researched a PhD on taxation and the right to education. She ably analyzed the fiscal sociological theory. Now, that information was very critical in understanding what informs the decision to levy certain taxes and spend money the way it was spent. It's being spent. Fortunately, that evidence helps here, but is slightly different from the angle that we are looking at. Because human rights and basic education in particular, vis-a-vis taxation, you are looking at realization. How do you realize the rights using taxation? How do you raise enough money to pay for free universal education? That was the thrust. This study is saying, no, let's look at it from the other angle. Let's look at the process leading to that money. Let's look at the how. You can be interested in the end result. It's important, but the how you achieve, and it is the process of enforcement that we are looking at. Ultimately, you are looking at compliance, but more interested, focused on enforcement process leading to compliance. So to that extent, there was that is literature that has been written on the subject. Another important point I want to talk about literature is that one of my supervisors, Professor Bachibinga, has extensively written on taxation in Uganda. But most of what he has written on has got to do with development. I think at a certain point, he eventually wrote on taxation, already tax and its abolition in Uganda, comparing it with Tanzania. So there is a lot of literature, but like I said, not enough, at least in Uganda, on enforcement and how the process of enforcement, bearing in mind the rights of taxpayers, helps improve compliance. And that's where my focus was. And what's my contribution? My contribution is that, yes, the moment you respect my rights, the moment there's a human face to the process of collection, that encourages a culture of compliance and ultimately increased revenue. Thank you.
Okay, moving on. We see, and I think it was evident in your presentation and somewhat in your thesis, that taxation evolves right from the start of society. That even before the modern tax system that we have, we had aspects of taxation in existing pre-colonial societies. Be they centralized societies or even segmented societies. Is there anything that modern taxation, in terms of correction and enforcement, can learn from the pre-colonial, tax arrangements?
When I talk about pre-colonial, I'm talking pre-1894. And I'm going back to even the 13th century, where societies were under kingdoms, and some were actually not under kingdoms, for example, in Karamoja and the rest. Pre-colonial period, you still had some areas which had some kind of centralized system of governance, like Uganda. Uganda had some kind of, you had chiefs and they had responsibilities to collect. What I find interesting is the authorization or the acceptance to receive taxes in kind. Mm-hmm. I am a farmer. I receive my goods at the end of the season. It's only when the season is done that I have goods that I can pay my taxes. That enabled compliance more easily. Today, you will find somebody with goods but may not have the money to pay the tax. You may find somebody has got a lot of cows, but URA wants cash. You must pay money in the account. So that allowance, that flexibility of allowing people to pay taxes in different ways, depending on their source of income or their source of activity, is something that I think should be considered and adopted in this. And there was less use of force. Less. which something that increased during the colonial period, where the colonialists would use the carrot and stick approach. In the past, yes, you had to pay the tax, but there was that flexibility that was allowed. And it's something that we can borrow and perhaps look at, not necessarily in kind, but some flexibility that allows you to pay taxes depending on the kind of activity or assets that you hold. Thank you.
Okay, so having said that, then, do you still find it problematic for the URA, for instance, to confiscate taxpayers' goods where they are delinquent? Having said, look, in the pre-colonial societies, they waited for when the harvest has come and, enforced at that point. What is the problem of the URA then coming and not going to your house, but coming into your store and, locking you up or even confiscating those goods?
Two problems. Problem number one, again, I said the process, how it's done. That is the power that is given in the law. But the power that is given in the law does not have intervention of a third party. We all know, I think not all, a number of lawyers present here are familiar with distress proceedings in the courts of law. You have two people, they have a dispute, they go to court, court rules in favor of one of them, gives a period that money must be paid. If money is not paid, you go to court, you apply to execute. You list the properties, you attach the property, you advertise it, you sell it, end of story. Here, the process is different. You have the URA, the tax authority, it has got an assessment, maybe, and I'm saying maybe, the taxpayer is disputing it. Maybe the taxpayer is saying there is no tax. However, as long as the tax remains unpaid, that tax remains unpaid, they can then institute distress proceedings without intervention of a third party. That's my problem. Where is the fairness? You, on the one side, are claiming tax. Me, I am saying it's not there. But you are exercising a power that ordinarily should be exercisable by an independent arbiter. That is not the case here. And that's where I find the problem. But relatedly, again, we came across a number of cases. There is a case which I would like to, in 1 minute, emphasize. There is a case of Wana Solutions Limited versus URA. In that case, it's a case which went to the Tax Appeals Tribunal. Wana Solutions had a problem with URA regarding taxes. They then decide to go and close the property. But when they close the property, they put seals. When they put seals, after 2 days, the auctioneer appointed by URA found that the seals had been broken. I don't know by who. That was never discussed in court, but the seals had been broken. When the seals were broken, the URA then found that some goods in that sealed property were being put on a truck. That truck was impounded, the goods were impounded and taken to the URA. Here is the interesting point. The law says you must sell that property within
10 days.
14 days, 15 days. That truck was impounded for 3 years. That truck was impounded for 3 years. That is a matter that went to court, and the court found URA to have been wrong and gave damages. It gave damages of 20 million shillings. I can't blame them. I can't blame the court because that's the whatever, the circumstances. But at the end of the day, you see where the problem comes. My truck is impounded. for 3 years. I cannot use it. Even if ultimately I get it back, the chances of wastage are high. So it is those issues that I look at that then make me believe that perhaps some of these, the implementation of some of these powers leaves a lot to be desired and can actually bring about infringement of rights.
Okay, so the Warner case seems to be, on the extreme side, in the sense that, there were delays on the part of the URA, they were more aggressive. But let's look at a normal situation, because as I understand it, your argument is that in respect to, and that's going to be my next question, in respect to other recoveries, there are safeguards. But we also have safeguards under tax laws, the Tax Procedure Code Act, one of which is what you've mentioned, that the sale must happen within 15 days. But, again, going back to a normal situation, the taxpayer has, when an assessment has been issued, they have the option to object within 45 days. That's one safeguard. If there are, objection, well, even before we go there, they have the chance to engage in ADR with the URA. Even if they choose not to do that, the URA must issue a demand notice for a number of days before it can actually, sell or encroach on, properties. And those enough safeguards, again, considering that taxation exists for a purpose, it exists in the public interest, it's the driver of the state. That the state should not be made to wait forever. Do you think those safeguards are still not sufficient to warrant, curtailment of, current URA powers of enforcement?
I want to be very clear, Doctor, with your permission. This study does not say URA has completely lost it. In fact, I have, that is something that appears every Thursday in the newspaper. Ask the Commissioner General what the URA has done, which is commendable. And like I said, what I am doing here is only to critique. I'm not criticizing. And the two are different. Being a critique and criticism, I'm critiquing with solutions. I'm not criticizing to say you are bad guys. No, I'm just giving a critique. This happens every Thursday. And in most cases, if you follow what happens in Ask Your Commissioner General, they are explaining some of the safeguards. They are inviting the URA, the public to come to the URA in the case there has been an excess, or informing people about their rights. And I agree with you entirely. There are safeguards in the law. I agree with you entirely that certain safeguards are actually being implemented. And that's why in my conclusion, I did say that there has been a general improvement. There has been a general improvement on the part of the URA. Having said that, is there room for improvement? Yes. Can they do better? Of course. The safeguards, let's take an example, a safeguard of agency notices. Whereas in the old law, when an assessment had been raised, there was, as long as there was a dispute, URA would never issue an agency notice on that amount. It was in the law. It was say you could collect except for amounts in dispute. That was amended. And it's my contention that removing that safeguard was a problem. Why? As you will see in my study, I give an example of the 2021-2022 report of the Auditor General. 8,600 and 63 agency notices were issued in that financial year, totaling over 4 trillion shillings. What happened? They collected 80 billion, which represented a 1.7% success rate. Some of these, the powers are there, the safeguards are there. Some are respected, but those that are not respected can have an effect of discouraging compliance. So yes, the safeguards are there, the safeguards are important, but what we have seen increasingly is that some of these safeguards have continuously been amended and removed, and more stringent measures enforced.
Okay, well said, but again, push back a little bit on that. So you admit that there are safeguards, but gradually these are being eroded and so on and so forth. But aren't we still in a better position, for instance, than we were, how many years? 2005, 2025 now, those are 20 years ago, where the mode of enforcement was to hijack men in their houses early in the morning. Those who were school going by then in the morning, you find people tied Kambona style, jailed. So if you compare then the days of graduated tax,
Yes.
And how it was enforced and its implications on rights, and the current days of an agency notice, where it's money in the bank, may even not be there anyway, because as you rightly say in the Auditor General's reports, so much of notices is issued, but only about, is it 88 billion or 8 billion?
80 billion.
80 billion
Yes.
is realized. So, for the most part, perhaps there will be no money. There will be no money. But isn't it a more humane approach than the approach of, for instance, arresting a delinquent taxpayer, as was the case during the days of graduated tax? So how far do you want to relax and make it comfortable for the taxpayer, especially the delinquent taxpayer? How far do you want to take it? Is it that if you stretch it so much, you actually have no enforcement?
Yes.
And as we know, a law, a tax that cannot be enforced is as good as useless.
Correct. I'll go a step back.
How many minutes? Okay.
I'll just go a step back. Uganda operates a self-assessment regime. We cannot have as many staff to ensure compliance. So at the end of the day, we operate a self-assessment regime. It is only where you do not comply that the law comes in. And that's when I brought up the voluntary and involuntary. You are absolutely right. There were more draconian ways, especially during graduated tax. And that partly explains why it was abolished, where you would have somebody arrested, taken in front of whatever, and just for purpose of collecting tax. However, with the changing times, sometimes what seems to be a simple non-observance can have colossal implications. I'll give an example. Away from agency notices, I'll give an example of confidentiality. We now know how everything is going digital. We now know how important data is. The difference between my business and your business can be in how much data I have. My secrets about my business secrets can all be in this kind of data. If you take that information and it lands in my competitor's business hands, you can see how damaging that can be. You may say it is simpler compared to arresting somebody and taking him to court, but it can be the difference between the survival of your business and the collapse of your business. So yes, I hear you and I agree that yes, there's been improvement, and there has been a remarkable progress in trying to ensure that some of these draconian ways are done away with, but nonetheless, there is still room for improvement, especially given the current times of the day.
Okay. Moving on to the 30% tax requirement. So one of the countries that you look at, obviously, is South Africa, where the tax to GDP ratio is among the highest at about 28%, tax to GDP ratio. Of course, there's Kenya as well. But what is, I think, interesting about the South African case is that actually, as opposed to 30%, they insist on 100% payment of the tax.
Yes.
And then on this other side of the world, we are saying, look, our collections are low. The tax to GDP ratio has stagnated, around 13% since maybe 2002 or so. Should we still then, aware of that, should we then insist on a complete waiver of the 30% payment?
Yes, and I think it has gone. Yeah, the South African case is an interesting case. South African case is that where there is an assessment raised by the South African Revenue Service, you must pay 100%. They actually operate what they call pay now, argue later policy. When in Uganda we are saying 30%. And I hear you say, aren't we better off than them? They are saying 100%, you are saying Uganda 30% and not even happy with that. Here is the problem. In South Africa, the pay now, argue later. The moment you contest the assessment and you go to court, the court has got power to stop the whole 100% and you litigate. In Uganda, if you contest the 30% and you go to court, we have got a wealth of cases where courts will say, our hands are tied. We have no option. So, which one is better? I am disputing the tax. You are saying pay 30%. Here, I am disputing the tax. You are saying pay 100%, but court can stop it. And that's where judicial intervention becomes important. The judicial intervention becomes important because all we are saying here is that 30% can actually be an impediment. I'll give an example. Something I mentioned in my, one of my respondents, a tax consultant, was faced with a situation where the URA was supposed to raise an assessment of about 30 million shillings against a taxpayer in Mpigi. The system, because everything is now done online, the system erroneously added zeros to make it 33 trillion shillings. 3 trillion shillings when it was supposed to be 30 million shillings. What that means is that if that taxpayer wanted to go to challenge it and pay 30%, he had to lose for 1 trillion. Would that be fair? Certainly not. However, I'm told what happened in that particular scenario is that they had to look for the taxpayer to come and lodge an objection online so that the system can be corrected. Again, I'm trying to say is that in the process, and I think I must commend the Tax Appeals Tribunal. Recently, the Tax Appeals Tribunal in the case of Agreco versus URA, for the first time, the tribunal said that you can not pay 30% when actually there is no existing assessment on an amount in line with the Felix decision. And what the tribunal was saying in Agreco is because in Agreco, it was a ledger problem. We taxpayers have a ledger in the URA, and it was a ledger problem, a reconciliation problem. The taxpayer was saying, I paid all my tax, but the ledger was showing there is some tax outstanding. So it is in those instances that I am saying, yes, 30% if would only be reasonable if you can allow judicial intervention in certain factors, especially where the tax is in dispute, which is the case in South Africa.
Okay, I think I'm pressed for time. I don't know how much time I'm left with. But one last, I've been given the chance to ask one last question. So your conclusion is that, you know, the ambitiousness, the aggressiveness of URA in tax enforcement is responsible for killing taxpayers' morale, is responsible for discouraging voluntary, you know, compliance, and so on and so forth, and with implications for domestic revenue mobilization. Now, you also say, and it's a fact, that you know, Uganda's economy is largely, predominantly informal. 80% of the economy is informal, you know, agriculture and hard to tax businesses. So it means that we are talking about just 20% of those that can be traced by the URA. Now, having said that, should our concern really be about how excessive the URA is in enforcing taxation, or should our concern actually be ways of bringing the informal sector into the tax economy?
Very interesting question, Doctor. Ultimately, the objective of taxation, the numerous changes, amendments made by the government and URA are to enhance compliance. And I hear you say, rightly so, that there are many factors that need to be addressed. Yes, continuously, most of the amendments address what I call the policy gap. But there is a difference between policy gap and compliance gap. And my study is actually saying there is a problem in the compliance gap. I'll give an example. Last Wednesday, the New Vision ran this article, URA to tax Ugandan assets abroad. That was this is not a new tax. This has been on the statute books. The problem is that it had never been enforced. URA is now enforcing something that has been on the statute books. So there are so many things that can be done. And I hear you when you say informal sector. We need to formalize our sector. Kenya is doing better than us because they are slightly formalized. South Africa is more formalized, more industrialized. That's why they are doing better. Yes, that is a factor, but not the only factor. Perhaps I need to emphasize it's not the only factor. What I am saying is that it can be a collection of issues. But importantly, what has not been addressed has been an issue of the compliance gap. Issues to do with compliance. And I must commend government. When you look at the domestic revenue mobilization strategy of 3 and even the current one 4, government makes it very clear that their strategy is not to increase the tax rates, not to increase areas of taxation per se. That will contribute only 25%. Government is saying their emphasis is going to be to strengthen and get 75% from the administrative side. That brings about certainty, that encourages investment. So, in a nutshell, yes. Do we need to formalize? Yes. Do we need to broaden the tax base? Certainly. Do we need to deepen and tax very few taxpayers at the expense of others? No. What do we need to do? We must go to areas that have not been taxed. Go to Ugandans who have assets abroad, who have not been paying tax, who have been making money and investing it abroad. Let them pay their fair share of tax. And I think for me, that's a move in the right direction. Thank you.
All right. Thank you very much. At this point, I want to hand back to the chair. It's been a pleasure having this conversation. Thank you.
The key word at first was quickly. Then it became ultimately. But ultimately, the motto of the PhD is panic, hustle, deliver. I think he panicked, he hustled, and the evidence is there. He has delivered. Thank you very much to our opponent, Dr. Ngabirano. You have exhausted, you have done well to weave us through. Mr. Kambona, please have a drink of water.
Thank you.
Because I don't know whether you've been able to drink some water. There is a next session. The next session will be 30 minutes or so of engaging with the panel members. That will be the 3 key panelists, excluding myself as chair. But I would also like to sneak in one quick question, maybe related to the substantive, maybe not, but I'll sneak it in before I allow the other panelists. So you've told us that Uganda has low tax compliance levels, at least as compared to other countries. And this has resulted in a conflict between taxpayers and the state, perhaps also into violations of human rights, property and privacy. Is it a failure in complementarity and participation of citizens in an economy in which every person should benefit? Is it a lack of trust of citizens of their state, or is it purely bad manners? What would be your take?
Certainly, I will start with the last one. I don't think it's bad manners. I think it's a mix of many issues. First and foremost, there's an awareness gap. There's an awareness gap in our society. Some people genuinely don't know a lot about taxation, or even something about taxation. When the strike was taking place, this traders strike, many of the traders were complaining that URA had introduced a tax called IFRIS. They had introduced a tax called IFRIS that was sending away our customers. IFRIS is not a tax. IFRIS is just a method that actually is beneficial to taxpayers. We may disagree, but in terms of a process, it fastens refund processes. So, on the one hand, Chair, there is a compliance gap. Sorry, a knowledge gap, awareness gap. But secondly, there's also a trust problem. The Commissioner General, the former Commissioner General, URA, Madam Doris Akol, wrote a paper on how to encourage compliance. In her paper, she made a quotation, which with your permission, 1 minute, I would want to read to understand where the concept of trust comes from. This is what she quotes a taxpayer saying: "Why should I pay taxes to a huge parliament that does not deliver? Why should I pay for a huge cabinet of ministers RDCs that have no value addition. Why should I pay taxes when we have children still studying under trees and yet we have a 54 trillion budget? Why should I pay when New Mulago Women's Hospital is only for the privileged? Why should it be the poor who look after the rich? When drought-prone areas have no water dams for their animals and safe water for their home use, where is the fairness of paying taxes when I have to sell 20 kilograms of maize to buy a bar of soap? Why should I pay taxes when there is unabated misuse of government properties, such as vehicles? Why should I pay taxes when the government prioritizes? Priorities are not people-centered. This is just a microsome of a problem. This is a taxpayer quoted by the former Commissioner General in her article. It goes to show the issue of trust. That some people are actually looking at payment of tax as a trap. They're not looking at it as something for their benefit. So when you look at that, then I said to you, it's also partly a question of trust. Can it be built? Yes. Can it be better improved? Yes. That's my take.
Thank you very much. So for the next 30 or so minutes, I'm going to invite the panelists to interact with you. And I'll start with Dr. Hilda Popakiu. Please ask your questions to Mr. Kambona.
Thank you, Dr. Zahara. Mr. Kambona, the last time I saw you was when I was in LDC, so today is really a very good opportunity for me to be on the other side of the table. But at the same time, when I read your thesis, I was very impressed. And I do remember drawing back and realizing that by the time you do your doctorate, at a level of the kind of practice that you have had, it becomes very easy to apply your knowledge in the writing process. And that reflects especially in the chapters that relate to application of the law. All right, I looked at your, I think, index number or registration number, and I really congratulate you for having been able to achieve this far within a period of about, I think, 3 to 4 years. So that is really commendable. Congratulations. All right, going to your paper, I'm going to ask 1 or 2 questions or seek clarification on 2 or 3 questions. You suggest that public participation should be enhanced. And somewhere in your thesis, you also mentioned that there has been very little attention being given to tax agents or consultants' views. All right? I'm going to draw your attention to page 133 of your thesis, and specifically the case of Kenya Bankers Association versus Attorney General, and another. It's on the first paragraph of that page.
130?
138, at least, yeah, 138, yes, 138.
Yes.
Yes, when I read this excerpt that you reproduced in this page, on this page, I was a little bit confused. I wasn't so sure what you're trying to say. Let me quote it. You say, in Kenya Bankers Association versus Attorney General and another, which challenged the constitutionality of retrospective increase in the excise duty rate from 10 to 20% in the Kenyan High Court. The Kenyan High Court held that whereas the enactment of retrospective laws in tax laws is not unconstitutional, the retrospective law is, however, deemed unfair and unconstitutional when its retrospective application is impractical and unreasonable. I was a little bit confused. Please, can you unpack that up? Because when I read through the detailed judgment, the court was very clear on certain key aspects, including public participation, including unfairness of the law, as far as its application on the Bankers Association is concerned. So please help us understand as a reader. Thank you.
Yes, Kenya is very big on public participation. In fact, I think they have got the most aggressive litigation process when it comes to overturning laws that did not go through public participation. Perhaps some bit of context. Before a law is passed, the law, a tax provision or tax legislation must be originated, a bill must be originated from the Ministry of Finance. And then views, and then of course it goes through Parliament, processes through Parliament, and views from different stakeholders are taken. Now, my problem is in the how it's done. Yes, there is a provision where you seek views. There is a provision where taxpayers are supposed to go to give their views. In fact, among the people's views sought is the Law Society. You get to understand how the problem, where the problem is, until you get to know the how, the implementation side of it. In Uganda, the time given normally is very limited. Number two, even where the views are taken, the chance that those views are considered is also very low. So the issue of public participation is actually a very, and that's why I recommend the need to enhance public participation. Why? Because again, I did mention one of the things we are investigating is experience, lived experience. We are also investigating behavior. Some of these laws can have an impact of actually affecting the economic progress, scaring away investors if you pass laws. So specifically to this particular case, yes, you are right. In that Kenyan case, the court mentioned that there was no adequate public participation. But it was dealing with a very interesting law, a law that was providing for retrospective application of tax laws, which is a very interesting area, even in Uganda, that legislation should actually not have a retrospective effect. So in that, rather than go to that aspect, the court was more concerned, did you talk to the people? If you talk to the people, was the forum representative? If you write to Uganda Law Society on Thursday and tell them come and present your views on Monday, the Uganda Law Society is an association of over 5,000 lawyers. Do you think that on Thursday evening, Friday, you will get the views of the lawyers before you present it on Monday? It is the how. And I have stressed throughout my study, the problem sometimes is not in the provision. The problem comes in the implementation. And that's where we need to focus our attention.
Okay, I was looking at another angle specifically in relation to the retrospective element, because the court was very clear to say, indeed, there are instances where retrospective laws can actually be enacted. But when it comes to criminal aspects or laws that touch criminal offenses, then there is a little bit of concern. And it actually listed circumstances under which retrospective laws can be enacted. So you need to look at that. And from a writer's point of view, you need to, this is, I think, in my view, distance yourself as a writer, so that the reader can know that you're not biased.
Correct.
When I read the case and I read your view, you are leaning only on one direction. But this case that you cited is very, very instrumental because it really balances the role of the National Assembly as well as the role of the institution in charge of the Kenya Revenue Authority, in charge of implementing the legislation. And even they argued and said, even though this law has a retrospective application, these bankers association have not actually been asked to pay retrospectively. So I think it's a very good decision if you look at it.
Thank you.
And try and look at it objectively.
I'll look at it.
And then there's also a case that you discussed on the same page, and it's constitutional petition E005 and E001 consolidated of 2021. I am very interested in knowing if you looked at the appeal decision that was the decision delivered on the 2nd of December 2022, because I don't see it here, but I think it would be good if you can draw your attention to that. Now, one last more question. Chair, do I still have one more question? You recommend that we should consider establishing a tax ombudsman.
Yes.
I do remember you said something about that in terms of are we not again going against what you're trying to advocate for to collect more revenue, yet when we establish new institution, it means that it's more funding for that institution. Now, I'm coming from a point of saying, why do we have to import best practices from outside when we have already the Human Rights Commission there that we can go and pick examples from to say, this is a human rights related issue of rights to property, rights to privacy. How is this already being implemented at the commission? You have come this far as an institution. What are the best practices that we can pick from? Do we need a new institution? We have the Inspectorate of Government. That also concerns leadership and how government servants fulfill their duties. In my view, I don't think we need, this is me.
Yes.
I don't think we need to import practices elsewhere. Maybe you could recommend that let us use it as a point of further engagement,
Yes.
not to import to say, let us create a new ombudsman, because South Africa has its own dynamics that has caused its successes and also some challenges as well. Let us have homegrown solutions based on the institutions that you already have. Look at the best practices, the successes and failures. And if we were to come and establish an ombudsman in charge of tax, let it be based on homegrown practices. Thank you.
Thank you. I hear you, and I think we must never be quick to rush to copy unless it is very relevant in our circumstances. But I would like to opine that I think we are at a point where we actually need that. And I'll tell you why. A tax ombudsman, but Kenya is in the process, is reviewing a legislation to appoint one, but Tanzania has an ombudsman, South Africa has an ombudsman. About 6 months ago, Nigeria introduced an ombudsman, Australia, again, many countries, UK. The difference here is that an ombudsman is interested with service-related complaints. He or she is not a replacement of the institution, for example, the Tax Appeals Tribunal. And I'll give an example. We have got instances where an importer, for example, brings in goods and has got a dispute with URA or the tax body, and the tax body disconnects the TIN, the tax identification number. You have goods, your TIN is disconnected, but you don't have a written decision. The TIN is not there, but you don't have a written decision which you can then now go to the tribunal and say, here is a decision and I want it corrected. So there are those issues that would definitely be easily handled by such an office like an ombudsman. But also, time is important. Doctor, I can assure you, Our institutions are doing a good job, fine, but time is not on our side. If you look at the judicial process, if you look, for example, at the Human Rights Commission that you are referring to, which could be doing a good job, the average time of disposing of a matter cannot be less than 1 year. In courts of law, you can find it, you have got backlog, which is over 3 years. Yet you have got a tax person whose business life depends on the outcome of that decision. Some of those decisions are not appealable as of law. And I'm saying you can still go to court, you can still go to the tribunal, but there are service-related issues. So I have written, let me give an example. You write an objection. Of course, there's a timeline which says 90 days within which you are able to reply an objection. Assuming there's something that happens and you want a quick decision, and something has exceeded, but you don't want to go through the court process, you can go to the ombudsman and have your complaint investigated. So efficiency is one aspect, time is a very big aspect, but also cost. Allow me state that it's not cheap to go through the court process. It's not cheap. You have to hire a lawyer. That includes money. And one of the things that I mentioned in my, maybe if I could show it, I could show the slide. The last slide on this comparative study is the ease of doing business. Uganda is ranked 116th in the ease of doing business. Kenya is ranked 56th. South Africa is ranked 84th. When people are making decisions where to invest, one of the things they look at is the ease of doing business. And the ease of doing business is informed by, among others, justice. How do you get your justice? How quick do you get your justice? How expensive or costly is it to get justice? If we are to improve on such ranking, we need to do things like I'm recommending. Thank you.
Dr. Chintu.
Thank you, Chair. Oscar,
Yes.
I congratulate you reaching this far.
Thank you.
You can clap for yourself for that. Meantime,
He came with mercenaries.
I realized that on this panel, I'm the only non-land educated friend since I come from the business angle. Okay. As you are told, I'm a lecturer in School of Business, and I meant very much into the legal aspects, but other aspects that make your work very nice and proper. When I listened to you and when I read your research, you're overemphasizing tax compliance, and I realize that it's your outcome variable. Why don't we rearrange your title to be the powers of URA for tax compliance, a lens of property rights and things like that? Okay, what's your take on that?
You rightly point, Doctor, that the emphasis is on compliance.
Yes.
Because ultimately, as a variable, you are looking and saying, is it improving? Or is it stagnant? Or is it regressing? Yes, so to try and look at that angle of the rights, I think is something that yes, I'll factor.
All right.
Yes.
Thank you.
It's also to mention that the title can't be longer than 20 words, and his title is exactly 20. So adding compliance will make it longer.
Yeah. Maybe it can be changed somehow, because the whole thing is about compliance.
Yes.
That's where I come from. Maybe you can see how you can change it somehow. if the supervisors permit.
Yes.
The other thing is, I noticed that you went to the field and collected data. But I don't see your acceptance to go to the field. Lawyers deal with evidence. I don't see consent forms. What's your take on that?
That's an interesting question.
Okay.
The ethical authorizations.
Yeah.
Now, first of all, broadly, Makerere University has come up with guidelines, has come up with a handbook providing guidelines on PhD scholarly work studies. When you look at that, when it comes to ethical approvals, it gives exceptions. And one of those where you actually need it, they say if you are researching on gender related. The other exception is if you are researching maybe in sciences and you are using human body parts or animal parts. The other exception is where you are actually dealing with issues that impact on persons' conduct and status. This particular one was purely about compliance, and so I sought guidance on that particular point. But when it came to the actual institutions, as you can see, quite a number of institutions were interviewed. That was granted before. Yeah.
Oh, maybe evidence will be need to be attached.
Yes.
All right. Moving further, in your problem statement, actually it's there, but it's lacking evidence. Did you evidence your problem statement?
Problem statement, yes.
So you're having issues of human rights violations, but I thought you would read about the URA client satisfaction survey,
yes,
to attach evidence because the statistics are there. Okay. So did you go further to read about the write-ups of URA and what they publish?
Yes, doctor. That is part of the methodology was document review. And what I could categorize as library research, where I conducted a study of and analysis of available literature. That available literature was then interpreted to see a correlation with information that we are getting from the key informant interviews, correlating it with the information that is actually in some of the studies that have been conducted. And rightly so, a lot of studies have been done on how things have been improving in the URA. Most of those studies were reviewed when they were making the domestic revenue strategy, mobilization strategy. And so most of the data is in that domestic revenue mobilization strategy.
Okay, but you need to include evidence in your problem statement about that.
Mention about it.
Evidence, okay. You put it in your problem statement. Thank you. Then you had to compare Uganda, South Africa, and Kenya. What is so special with those two countries? Why didn't you compare with Egypt? Why didn't you compare? Why didn't you compare with Egypt? Why didn't you compare with Nigeria and you chose Kenya and South Africa? The reasons are not there.
Again, if I could project, again, I did mention that choice of these countries is primarily two. Number one, Kenya. First of all, during the colonial, about 1958, we had this East African community laws, but subsequently, I did mention that before the current law, And before we had the income tax decree, which replaced the East African Income Tax Management Act. Kenya, the point I was trying to bring out there is that Kenya was almost at the same level, in the same category with Uganda when it came to taxes. That when with the disintegration, Kenya went its own way. So Kenya represents a tax system within the same region, East Africa. And therefore, for purposes of comparison, you need somebody that you can relate closely to. Less industrialized, slightly informal, more informal. So but doing well on compliance. So that is one. Then you want to look at the best case, the shining boy, the shining star. In Africa, the shining star or shining woman, this is South Africa. Why? It's collecting 28% of its GDP. That means for every 100 shillings, it collects almost 30 shillings. Yet we are collecting less, much less. So why South Africa? Because yes, you want to compare somebody that is almost closer to you and somebody that is doing much better than you. South Africa, like I said, has a slightly sophisticated system. Whereas South Africa recently received its what you could call its independence from apartheid, the eradication of apartheid in 1994. South Africa has a sophisticated, industrialized, and formalized economy. So I needed to do the both.
May I recommend
Yes, sir.
that you include a paragraph in your background
Yes,
justifying why you chose
yes,
Kenya and South Africa to compare with?
yes.
Currently, it's missing.
Okay.
All right, thank you. You mentioned in your methodology that you conducted FGDs, but in your analysis, I'm not seeing any indicator of FGDs. To whom and where is the analysis?
Actually, and I'm thankful for raising that. In the context in which I mentioned focus group discussions, which you are referring to, was the context of saying that is one of the methods together with interview, because you have three. You can have key informant interviews, you can have focus group discussions, or you can have you can conduct an observation. So yes, no, it was in the context of the available options, but the one that I critically emphasized on was key informant interviews.
Then
So,
in your
that's-
write-up, you need to change the wording because
Yes.
it shows that you conducted
Yes.
FGDs,
Yes.
which don't have any
Yes.
nice. Still in methodology, you have doctrinal legal analysis methodology. You haven't talked about it when you are presenting.
The what?
Doctrinal legal analysis methodology.
Yes.
You have overemphasized qualitative.
Yes.
How did it mix? And my question is, why didn't you mention that you did a mixed methodology, but not qualitative? Yet you have doctrinal analysis methodology also mentioned in your work.
First and foremost, the doctrinal legal analysis is important where you have got a historical aspect. And I hope you agree with me on that. The moment you are trying to interpret something that needs you to look at the historical, you need a method that gives you that latitude. And you could ask as well, why didn't I do a mixed with quantitative? Because again, here, we are not looking for empirical data. We are looking at how do you interpret lived experience? How are people responding? What are their motivations? And as the opponent, Dr. Ngabirano, did emphasize, a lot of what is happening today could do well by borrowing from our history.
Okay. when you are explaining, I had in my view that maybe you should have told us a mixture of doctrinal and qualitative. I don't know.
Okay.
Then in your write-up, there is a kind of slight mix-up on your respondents. Maybe you were not well organized in writing about that. Is it possible to draw a table showing the respondents and their numbers, and you don't leave out any? Then I go to my next question. I don't see High Court in one of your respondents, yet it decides so many tax cases. Did you go there?
Interesting. Yes, that's an interesting point. The reason that, for example, the Tax Appeals Tribunal appears, as you will see, I am saying courts of law, including the Tax Appeals Tribunal. Most of the decisions we are talking about from the courts of law are available and we are reviewed.
But you specifically mentioned Court of Appeal. That's why I asked, why not High Court?
Yes, I think that will be included.
Okay. All right. Okay. Still on methodology and maybe afterwards analysis, you didn't mention any way how you're going to analyze qualitative data. And there I ask, at what point did you reach saturation to say that I stop here? And how did you come up with what you included in analysis, yet in your methodology section, you don't show us how you went about analyzing qualitative data?
Okay, I did mention, and again, I did mention that one of my research design was descriptive and analytical. What are you describing? You are describing the experiences. What are you describing? You are describing the views. In fact, you are describing different perspectives. The moment you go qualitative, you are likely to encounter different perspectives. A taxpayer in downtown may look at something different from a taxpayer who falls in the large taxpayer department. So the point you are asking is that how did I analyze the data? You can analyze data by coding. This, because you are dealing with perspective, I did not have to go to coding. What did I do? I quoted.
Okay.
And that's why you look in my thesis, there are so many quotations. So how do I report? I look at what did the taxpayer say? What was the background? What's the context of what they were saying?
Implying that you went to the field with themes that were going to be answered.
Yes, and in fact, you can as well argue that you can go to the field you can look at things from two angles. It can either be deductive or it can be inductive. In this case, it was inductive. You have a position which I mentioned that if you respect taxpayer rights, you are likely to foster a culture. So you already have a mindset. One of my limitations, and as you will see there, is the bias of the researcher. As a researcher, I had the bias of either being a taxpayer or being a tax litigator. Okay. So with that in mind, yes, that's how I approached it.
Okay, maybe a paragraph or 2 lines on explaining how you went about it.
Okay.
Otherwise, it's missing. Chair, 2 things to complete. I'm sorry. In your recommendations, you talk about tax awareness, but I understand that URA has so many measures for tax education and tax awareness. The tax catalysts, web portal, ask the Commissioner General. In particular, what do you mean and what do you refer to? Because all those initiatives, what hasn't worked that you need URA to address?
Now, I think I need to go a bit deeper. in this issue of tax awareness.
Mm.
You see, when most of your programs are telling me how to pay, where to pay, what income falls in taxable category, I will listen. But there are instances where I want to hear, what are you offering me? What service are you giving me? In fact, with your permission, I know time is not our ally. I will quote again what the Commissioner General, the former Commissioner General, quoted. This was somebody who had a comment, and he said to a URA staff, then how come most of big projects like roads are financed by loans mainly from China? Also show us the expenditure of the money collected. And this was the response from the URA official. He says, Barije Namara, I think you should direct your question to Minister of Finance, which is responsible for planning and allocation of revenue collected by URA. Is he right? He is right. Legally, Minister of URA has nothing to do with accountability. But is that the best way to put it?
No.
Perhaps no. So it's that kind of awareness, education awareness, that you're not going to only come and teach me how I need to go and register for my team. That is important, because URA has got a facilitative role to play beyond enforcement. They are supposed to facilitate taxpayers in complying with tax. But there are some of these areas that need to be covered in tax awareness. Thank you.
Thank you. I do have a recommendation also. When you go to your theoretical framework, you tell us something about social contract theory, you discuss it, but you do not show us the weaknesses in that social contract theory that lead you to adopting the human rights-based theory. If that comes out very well, because we need to know why social contract theory, what are the weaknesses in one theory that lead you to adopt another theory, which may make the reader comprehend and understand.
Yes. Social contract theory emphasizes a key word, contract. That is an understanding between me and you. We have a contract. If you breach your part, I'm entitled also to breach my part. But that's not the way it's happening. That's one of the shortcomings. That yes, whereas there is a social contract, whereas there is that aspect of demanding for the other side, as Dr. Ngabano rightly pointed, it's not a quid pro quo. We know taxation as not quid pro quo. That's the foundation under which taxation starts. It's not quid pro quo. When you are paying tax, your role is to pay tax. And that is a shortcoming. That's the shortcoming.
So may I recommend that it becomes a short paragraph at the end of your social contract theory, then you introduce the human rights-based theory.
Thank you.
Then lastly, Chair, coming from the other angle, the other side, what have you changed? A small thing you have changed with your work that we can go out with from this room. Thank you.
Yes. Like I said, when I was reviewing my literature, I did mention importantly that a lot of concentration has been done on the policy side. You have got laws being amended every year. You have got regulations being passed. A lot of focus on the policy side. Little focus is on the compliance side. What this study is saying, and it's very interesting that even the domestic revenue mobilization strategy 3 and even 4, none of it is talking about the role of observance of human rights. The need to respect, the need to protect, and the need to fulfill human rights. So the input that this study brings in is trying to bring in the angle of bring a human face to the implementation side, and that will improve the culture of compliance. I must state that one of the areas for further research that I emphasize is for a future study, for somebody to go and look at the impact, the further impact of this, to get data and say this brings about this in these numbers. That is for future study. Thank you very much.
Thank you very much, Dr. Chintu, for your focus on the methodological issues. Oscar, some of these are comments, so please take them in good regard and enrich them as you improve. Colleagues, there's only 10 minutes per panelist, but the panelists also share written comments. So there's a lot more that the candidate will benefit from the panelists. I'd like to recognize in our midst the presence of Ms. Crystal Kabajara, Chairperson, Tax Appeals Tribunal. Thank you very much for joining us, and also the Deputy IGG, Mrs. Anne Muhere, who has since left. Thank you very much. Our last panelist is none other than Festus Akunobera. You have the floor.
Thank you, Chair. It's an honor to be back here at the law school, a place I left roughly 20 years ago. It's amazing how time flies, but even a bigger honor to be on the panel for examining Mr. soon-to-be Dr. Oscar Kambona.
I take that with both hands.
Thank you.
Please don't be too quick. He's not a prophet.
Yeah, so first of all, I must commend you for the work you've put in. You have put in quite a lot. And for somebody who is a busy practitioner, to have done this within a space of 3 years is quite impressive. But most fundamentally, the depth of engagement with the authorities, the legislation, and the comparatives from across the jurisdictions is quite commendable. Now, I see that you focused on two fundamental human rights, which is the right to property and the right to privacy. I consider that in order to fully realize these rights, the right, I'll call it right to natural justice, is a crucial subset of these two rights and must therefore be taken as intertwined with those rights. Specifically looking at Article 42 of our Constitution, which says that an administrative body must act fairly. Closely linked to that is Article 28, which is the embodiment of the right to a fair hearing. And the right to a fair hearing postulates two scenarios. One is the right to be heard in the first place, but also the rule against bias by the arbiter. My question to you is, are you concerned? Is there anything within our tax, legislative, and administrative framework that makes you concerned that we do not have sufficient safeguards of natural justice that would otherwise impair the full realization of the right to property and the right to privacy?
Yes.
We can first start at that.
The short answer is yes. But the long answer is that the dispute, the complaint and dispute resolution mechanism that is in place ordinarily should have that aspect of natural justice and fairness. And that's why the human rights-based approach is encouraging that human face. Is that the case today? Do we have what you call natural justice? Again, my answer is to a certain extent. First of all, the dispute and complaint resolution mechanism in place under the legal and institutional framework recommends exhaustion of local remedies, internal remedies. What does that mean? Currently, if the URA raises an assessment, a taxpayer has got 45 days within which to object. So you're expected to use that time to gather as much information and give it to URA. URA then has got 90 days within which to respond. If the objection decision is against you, the taxpayer, then you can choose to go for what they call alternative dispute resolution, again in the URA. But at the same time, you have got 30 days within which to go to the Tax Appeals Tribunal. So those can be done concurrently, and the tribunal has rightly pointed that out. But in the internal mechanism, there is supposed to be that fairness where I am given an opportunity to express myself, and whether that actually brings out the aspect of justice depends on how you perceive it. But I agree with you, like I said in the short answer, I agree, yes, it's important that what the Constitution in Article 25 emphasizes for administrative bodies should be actually mirrored in our dispute resolution process.
Thank you very much for that. And so I would just implore you to consider the possibility of integrating elements within the analysis of where you think there could be omissions within the framework that may otherwise impair, especially the rule against bias. And I'll point out especially in the field of agency notices, which is the second point I'm going to come to. Agency notices and the 30% rule. The determination of whether you pay in installments tends to be by the same person who has been given targets.
Yes.
So how do we protect the taxpayer against inherent bias?
Yes.
Such that then we can protect the property rights that ought to be protected.
Correct.
So that is something I would encourage you to look at. Now, going into the enforcement measures, I see you've captured four broad enforcement measures or powers that the URA has. But I just wanted to focus a little bit on the 30% measure. I am impressed, and genuinely so. I don't want to say this to my senior, but I'm genuinely impressed by the depth you've gone to examine the Upmark decision, the FuelX decision, and the recent TAT engagement with those two decisions and where they land. My experience as a practitioner seems to suggest that because we are so rooted in precedent, in the doctrine of precedent, there's very limited flexibility for the TAT and the courts of record to depart from established precedent or to engage meaningfully to deliver justice in circumstances where justice is extremely demanded.
Correct.
And I'll give you scenarios, but again, mindful that we don't have a lot of time. I have dealt with a scenario where a water company is being audited and the tax authority is saying the person has underdeclared. But when you examine the records, you see in water manufacturing, you have about 3 or 4 different pieces of raw material which build up this bottle. So you'll have this, you'll have this, you'll have this.
And the product.
So yes. So the auditor just went and said, I have seen you procure materials of 4 different kinds. Therefore, you must have procured 4 bottles. So for each bottle, the auditor is counting 4 bottles. And is therefore saying you've declared 25% of your total revenues. So when you look at the size of the company and the size of the assessment, they are literally sending them into bankruptcy, confirmed guaranteed bankruptcy, if they tell them pay 30%. The unfortunate conundrum we're in is that 30% has been taken to be mandatory. So the taxpayer is stuck, and the courts under TAT have been given very limited flexibility. I know you've advocated for enhanced judicial enforcement, engagement.
Engagement, yes.
Would you consider that it's necessary for us to have a prescriptive legislative approach to dealing with scenarios where we might have to waive this 30% requirement? That's one piece.
Yeah.
The second piece, would you consider that that role should be taken away from the tax administrator for purposes of bias, which I pointed out earlier, in order for that to be determined by a separate adjudicator, especially, as an example, the TAT? Because as you know, before you get into the merits at the TAT level, the preliminary question you must deal with is whether 30% has been paid.
Yeah.
Would it make sense on a prescriptive legislative approach for the TAT to be empowered to examine that question and make the final call, whether one, a waiver is justified in those circumstances, or two, whether an installment scheme can be justified, such that before you even go to mediation, that's the first question
Correct.
that is dealt with.
Correct. Correct.
What would be your comments on
Yes.
that?
First and foremost, I want to agree with you entirely that something must be done about the 30%. I want, for purposes of completion, I want to state that there was actually a legislative process that removed 30% from all other laws. There used to be 30% in the Income Tax Act. It used to be in the VAT law. It was removed from those laws. And that was the time when they were trying to amalgamate the procedural provisions under the Tax Procedure Code, to bring all the procedural provisions. They tried, it's in the Hansard, they tried to include 30%, to remove it and put it only under the Tax Procedure Code. Parliament refused. Parliament said, no, it is you're taking away fair hearing and access to justice. So it was dropped. However, it was not removed in the Tax Appeals Act. That's where it remained. And for it to be removed, Ministry of Finance must originate a bill to remove it, and they are not willing to do so for now. So I agree. There is need for engagement. There is a need for dialogue on this whole issue about 30%. It's my hope that this study will contribute to that debate, that this study will engineer a thinking when the policy makers look at what the recommendations are, they may have to rethink this whole issue about 30%. And allow me to say, you make a very brilliant proposal. Why don't you, if you are to maintain it in the tribunal, then give them the mandate to look at situations whether they should actually enforce it or stop it in the first place, away from a body that has an interest. But like I mentioned in my presentation, the tribunal has been progressive in this whole issue, because for the first time, the tribunal is saying we're not going to close our eyes and just agree that it's mandatory. We are going to look at the circumstances on a case-by-case basis. And on that, I think we will be making progress. But lastly, you point about installments. There is a case I cite, Century Bottlers, Coca-Cola. Coca-Cola had an assessment of 59 billion shillings. It went to the Tax Appeals Tribunal, and that was shortly after COVID. Everybody knew the consequences companies went through during COVID. Coca-Cola applied to the tribunal and said, can I pay this amount. No, first it applied to URA. And then URA said, well, the law says 30%. But the tribunal accepted. And Coca-Cola was allowed to pay that in 4 installments. Progressive decision, I must say. And I think in the right direction. So, but why do we have to wait for such situations on a case-by-case basis? You may ask, perhaps the point you are saying, can we have a legislative process where all these things are streamlined and the law is streamlined? And I say, perhaps it's the right way to go. Thank you.
Thank you very much for that. The chair is obviously reminding me that we're past time, but I just wanted to capture 2 short points. On the question of the agency notices, obviously this, as you know, is one of the sticky points. And the presumption, as you know, when people are legislating is that the enforcer of the law will be rational.
Yes.
That doesn't always play out.
Yes.
As expected, as you know from the Frank Babibasa case, which you have quoted, where someone ends up issuing an agency notice even before the period for objection has expired. That, as a matter of record, is something in the distant past. But even in modern times, there are still anecdotes where an officer who is overzealous has attempted to do that, even when the rights of the taxpayer have yet to be fully explored within the timelines provided by law. Now, I see that you've made the point in your thesis that even if there was a premature collection or an unlawful collection, the law has provided a remedy whereby if you're right in the end, then you can be compensated by way of interest.
Yeah.
So that's a positive development within the law. But is it, in your opinion, sufficient incentive to deter this wayward behavior, which tends to show up every once in a while?
Yeah.
Or would it make sense to introduce some pecuniary punitive measures on the part of the URA in order to totally discourage this kind of indiscipline?
Yeah, and I agree. Both are necessary. Interest is important. What the law is saying, if you take my money and tomorrow the court finds that the money was taken wrongfully, the assessment was wrong, I'll give back the money and I'll give you interest. But there's a problem in that. The law is saying we shall give you interest from the date you apply for that interest to be refunded to you. That's the problem. You took my money in 2014. We have been in court. You have been with my money. In 2024, 2025, judgment is passed and you have to refund me my money. Then I have to apply for that money to be refunded. Interest is calculated from that day, not 2014. That's the problem. And it's the apparent infringement that I mentioned. That you have my money and that money can only attract interest from the date I apply for it to be refunded. There's a problem. But there is also another problem. The problem of implementation. Yes, there are safeguards. There's another safeguard that I mentioned in my thesis. An agency notice, if you are writing to my bank to take my money, you must serve the bank at the same time serve me. Concurrent service. So that I am aware that money is being taken or an application has been made, a notice has been served to take my money. That is a safeguard. But in some instances, again, that's where the case law becomes important. There is a case, and it fits in with your last point of the punitive damages. There is a case of Stanbic Bank, Uganda Limited, and Jacobson, the energy company, that used to give thermal energy, there was an assessment against Jacobson. Jacobson went to the tribunal and filed a case. At the same time, URA issued an agency notice on the bank, on Stanbic Bank, who are the bankers of Jacobson. Jacobson was informed by the relationship manager in the bank and rushed to court and got an injunction against the agency notice. By the time the injunction was served on the bank in the afternoon, URA had gone to Stanbic Bank and was threatening to arrest the managing director. And the point was, the agency notice was saying, pay now. Now can mean 1 minute after now. Now, the managing director of Stanbic decided to pay and paid the money to URA and said, well, you go and have your fight. I'm not going to be part of this fight. This is what happens. Stanbic Bank then filed a case against URA together with Jacobson and was saying that that was improper and illegal. And in fact, Justice Mulia Gonja of the High Court then, she was still in the High Court, ruled and said that high-handedness must stop and penalized URA in damages of 100 million shillings. Unfortunately, that money was going to the government because it didn't say give it to the taxpayer. But the point I'm trying to make is that, yes, there are those excesses that we have identified. It is important that a discussion starts now. Perhaps, and I think through this study, that some of these methods, some of these powers need to be humanized and, you know, a win-win situation is obtained. Thank you.
For Mr. Kambona's voice to still be the way it was from the beginning is amazing. Thank you very much. Now we have an engagement with the public. If there are any questions, any persons who would like to ask, we'll take a round of about 5 because time is not on our side, and then we'll wrap it up. We have a microphone moving around. Yeah. Okay, microphone, Mr. Male Mabiri is here. Interesting words on your T-shirt. You have been allowing us to see them frequently. 1 minute.
1 minute.
1 minute.
Mr. Kambona, my problem with your study is one.
Ask the question, Mr. Male Mabirizi. Ask the question.
The question is, why are you promoting corruption as opposed to accountability? When you overstretch the right to privacy and property,
Okay.
relying on the Supreme Court, Constitutional Court decision of ABC Bank, are you not allowing these corrupt people to hide the money so that we cannot tax it?
Thank you.
Yet we as citizens, we need that accountability to see how they earn so that we can tax it.
Thank you very much. The gentleman in the maroon T-shirt.
Mr. Kambona.
Your name, please.
Anthony Kajimu. To what extent is the URA scorecard responsible, or could the URA scorecard be pushing the abuse of property rights? Because when you look at their performance, they only emphasize the percentage of their target they collected, and there is no speaking to the mechanism in which it was collected. There is nothing like costs they lost or refunds they've paid. Would changing their scorecard help to give better protections to the property and privacy, because in that case, they wouldn't abuse it since we'll be paying attention to it. Currently, we only pay attention to the percentage of billions or trillions collected or not collected. And so as long as that doesn't come out, there will be no incentive from their side to change that. Is it something you considered? Is it something you like to look at?
Thank you. Thank you very much. Any other questions coming up? The lady next to you.
Thank you, Mr. Kambona, and congratulations for this milestone. My name is Crystal Kabajwara. Just some context to my question. You began your presentation with the low tax to GDP ratio. And when you look at a low to tax GDP ratio, it implies that the nation is more dependent on non-tax revenue, such as aid, as opposed to tax revenue. So have you considered the theory that when a government relies heavily on aid, it makes it less accountable to its population and more accountable to its donors, and therefore it abdicates on its responsibilities to taxpayers, and that could perhaps explain why you have a disregard for taxpayers' rights. Second question is, what is the relationship? Have you considered the relationship between how URA's revenue collection targets are set and its impact, and the impact that has on taxpayers' rights? Does the pressure to meet targets also lead to a disregard of these rights? And lastly, on the point of accountability, beyond holding URA as an institution accountable, what mechanisms exist to hold officers of the URA accountable at an individual level to deter abuse of human or taxpayers' rights? Thank you.
Thank you very much, Chairperson, Tax Appeals Tribunal. Any other questions? Those are already 5 by virtue of her office. She asked, okay, let's take the last one at the back. Gentleman at the back.
Yeah,
Tell us your name and where you're from.
my name is Jason Arinda. Concerning the question of accountability that you talked about, did you, in your research, maybe find a scenario where the taxman has been able to have a say on how the tax is spent, or hold government institutions accountable on how they spend that money, so that they can be able to answer the taxpayers when they ask questions of accountability? Thank you.
Thank you. Mr. Kambona, over to you.
Thank you very much. I'll start with Mr. Mabirizi. Mr. Male Mabirizi. Am I promoting corruption? No. That's the short answer. I am not promoting corruption at all. What I am promoting is ethical, proper processes, due process. Privacy. The case you are referring to, ABC case. What happened is that URA, in this particular case, wrote to 20 banks and said, give us information about Mr. Mabirizi, give us information about all your customers, their account number, how much they have on their account, when it was deposited, etc., etc., etc. The courts, the banks challenged it before the Constitutional Court and said it was unconstitutional. The Constitutional Court then ruled that, yes, you have the power to ask for information. You have that power. I mentioned access to information and documents. But it was saying there must be a dispute. There must be a dispute. I have my account. I am not having any tax obligation. You are asking information about me. Is that right? So there is no corruption there. What the court was saying, if Mr. Mabirizi has got a problem and URA is investigating Mr. Mabirizi, write to the bank will give you information about him. But don't go on a fishing expedition. Don't just throw a net and say, I will see what I will find in there. No, that court was fun. So privacy is very important, because why are you disclosing my information? Me, I'm a compliant taxpayer. You are piling me with other people who are not complying. That's where the problem came. Secondly, Mr. Kajimu, scorecard. What is the scorecard of URA? I think the scorecard, you are right, as you rightly point, is target. Last financial year, URA was able to meet its target. You should have seen the jubilation. It was able to meet its target. I think it collected an excess of about 300 billion shillings. Why? Because that's the target I'm given. That's the yardstick on which I am measured. So you are right. If you put emphasis on scorecard, I am under a lot of pressure to ensure that I hit my target. So maybe something, food for thought, we need to start thinking, can the scorecard, that yardstick of target, also be expanded in, for example, how many complaints did you receive against you? Could be that. How many satisfied taxpayers are there in Uganda as a result of your activity? Could be that. So I agree with your position that maybe that partly changes their focus. Ms. Kabajwara, you raise. I will start with the second one, which is more or less in line with the scorecard. Relationship between targets and impact on rights. I think I don't want to overemphasize the point. The point is that if you give me if I go in an examination and you set an examination and you set the instructions, if I don't follow the instructions, I have failed. Do I want to fail? No. What are the instructions for URA? Collect this amount of money in this financial year. What do? I have to use my powers. I have to go for people who are trying to play around, people who are delaying, and I must go for them hard on. I must issue 8,663 agency notices so that I can get as much, maybe. And I think the point there is that, yes, perhaps there is a need for a rethink and see whether we can perhaps, yes, emphasize targets, but also bring other parameters to measure them. To your first point, the GDP to tax ratio is low, granted. This year, last financial year, 13.9. And the president has been very critical about this point. From 2011 to it has been oscillating between 11 and 13.9. The president mentioned it, I remember, at one time. And he was saying, why? And the answer is simple. We need to do something different. We need to do something different. But your point is that we then rely on grants. We then rely on even loans. We are borrowing. Look at our debt to GDP ratio. We have crossed the 50% mark. We have crossed the 50% mark, which the IMF says is the most optimal. Does that affect the whole process and obligations of taxpayers? Yes. Grants, loans from multinationals, especially grants, are reducing. You are aware, as I think many people are aware, when Trump became president in the US, the first thing he did is he appointed Elon Musk to go and reduce the budget on foreign activities of USAID. Money that was being given to countries through USAID was reduced. That means our health budget was affected. So increasingly, we cannot rely on grants. We cannot rely on aid. That's not sustainable. What is sustainable is if we can mobilize enough revenue to meet our budget. And I'll tell you this. If you look at the domestic revenue mobilization strategy 4, if Uganda is able to achieve 20% of GDP in collection, we will be able to collect, according to their estimates, we will be able to collect 71 trillion shillings. Now, our budget is about 72 trillion. Of course, if that was the same almost last year, although what was actually absorbed and used was much less. But even as at a level of budgetary, you have got a 72 trillion budget. And if we collect 20% of our GDP, we shall be collecting 71 trillion. It goes without saying, I don't need aid. I don't need Donald Trump to give me aid to be able to run my country. And I think that is the way to go. Lastly, accountability. And I like your point. Can we reach a stage where we are holding officers accountable individually? You will remember that under the vicarious liability, police officers who, for example, exceeded their powers you would only sue Attorney General. I think now you can actually sue the officer. A police officer who exceeds his mandate can be sued. Why don't we do it through URA? Time for because that's something that's something food for thought. Maybe that can help bring. And lastly, Mr. Arinda, your question is on accountability. Does the taxman have a say on how money is spent? I think no. And I think we have to be fair. Like I said, I am here to critique. I'm not here to criticize, but I'm here also to give credit where it is due. I think sometimes asking more from them when it's not within their mandate is not fair. I think when it comes to issues of accountability, how are taxes used? I think that should be a question that should not necessarily be targeted to URA. However, having said that, it may be important for what you call a synergy, combined effort. When you are going to talk to people about taxes, you don't have to only be URA. You can bring the relevant ministries. You can bring somebody from Ministry of Works to talk about how many roads have been constructed. You can bring somebody from the Ministry of Finance to talk about how the budget is formulated and how much has been assigned to areas. That way, you're not putting the burden on URA. You are spreading it. And the relevant government entities are able to explain how accountability issues are resolved. Thank you very much.
Thank you. Colleagues, we have a very big online audience. And I would like to request that we allow at least one question for inclusion. Can we have the person who has had their hand up for the longest period to ask a question, if possible?
Chair, we have over 200 participants online, or we have one. There's someone who has brought up the hand. Let's see. Can you please project and we see? We say hand up. You can allow him to ask the question, please.
Who's that? Yes, go ahead. The name? I can't see from here.
Yes, Kanyango, Darlene, Miss Kanyango, Darlene, you can unmute and speak.
Can I be heard?
Yes, you can.
Yes, I understand the IGG was present in the audience, but she left. Considering the challenges that Mr. Oscar Kambona has highlighted in his research, can the IGG consider establishing a tax ombudsman department within URA to address tax-related challenges? Because we live in a country that has different quote-unquote useless offices like presidential advisor on ghetto affairs. Can't we really have an office in charge
Thank you
of
very much.
improvement
Thank
of
you.
tax
Oscar.
administration? Thank you.
Over to you, Oscar.
Thank you very much. I think Mr. Kariango, if I got the name right. Yeah, Mr. Kariango is saying in short, can the IGG also take on URA and investigate? Now, I want, can you please project? Sunday Monitor said 25 billion stolen every day, says IGG. Ladies and gentlemen, they have a lot on their hands. Where you are going to investigate 25 billion stolen every day? Do you have time to go and talk about URA? I think it may be asking too much from them. Thank you very much.
Mr. Kariango, did you connive with Mr. Kambona? This question was too apt.
I don't know Mr. Kambona in person.
We can take one more. There's one more, just one more hand up. Ellie. One more hand from, yes, Ellie.
Are you okay with it? One more? Okay, one more, just one more.
Yes, Ellie, please submit.
Okay, my name is Eli Karohanga. I have a bias because I have a relationship with your candidate, Oscar. We started Kampala Associated Advocates together. We are partners up to now. He has been heading the tax department from day one. It is very difficult for me to ask a non-biased question, and in fact, I can't resist making a comment about him, and generally about the intellectual world. First, this is my first time to attend someone defending his or her PhD thesis. So I am extremely pleased that I have had time to listen from the first sentence up to now. 2, I want to thank the academic world, especially in Uganda and at Makerere University. First, tracked a candidate of the caliber of Oscar to use Makerere as the university to get his PhD. Normally, Ugandans would want to run to other universities around the world to be accorded this high position. I want to thank him for respecting our institutions and to give credit to his examiners and to this panel. 2, I want to thank Oscar for dropping very serious, high-earning, lucrative legal practice in the law firm where we are practicing and spent so many years studying and dedicating himself to improving not only himself, but to see that he can touch through his research legislation that would affect thousands and thousands of people in the private sector. Then also, for people who don't know him personally, but who are in the audience and listening, I want to tell you that before you have a very, very, very unique human being, dedicated to his country, extremely brilliant as a person, who renders so much credibility and honor to us who work with him. So he's honest, he's level, of intellectual prowess is unmatched. I'm so happy that I am witnessing Oscar's advance. Not only does he just want to advance himself, but he finds time, in spite of being a very active legal practitioner, to go and teach young students at Law Development Center and give speeches around the world about Uganda's position in the world as an investment destination. It is with great privilege that you have given me an opportunity to say something about someone I hold so dear and so high in my humble estimation. As a person who has been a leader and chairman of Uganda's Private Sector Foundation, and still a member of its advisory committee, a trustee of the Uganda Chamber of Mines and Petroleum, who has been serving as its chairman, touching the lives of the people in the private sector, facing untold suffering from the private sector by previous URA regimes, making it almost impossible to do business in Uganda. It is important that someone has come out in a simple, humble way and presented this thesis. This has been something lacking, and thank you, Oscar, for filling the gap. I hope my statement is not meant to make you pass your PhD if it is not worth it, but as far as I'm concerned, I take off my hat for you with great reverence, and I honor you. Thank you, Oscar, for making not only your family proud, making our law firm proud, and making me, your personal friend, so happy. Thank you for giving me this opportunity.
Thank you very much.
Madam,
I think
Madam Chair,
we could
allow
not have
me-
wrapped it up any better.
just allow me 1 minute. Allow me 1 minute to thank. Of course, it's a comment.
You know, you will have time to thank after the verdict,
Okay.
depending on how it goes. So please, Mr. Karuhanga, stay online. Wait with him because this is the critical time now. If for any
Thank
of
you.
you,
I stay
maybe
online.
some online hankies because he might be sweating. Allow us colleagues to deliberate on the outcome and we shall return in not more than 20 minutes. Thank you. And at this moment, Oscar, I think now you can thank people you may have thanked and then the verdict was different. Now is the moment to say something.
Ladies and gentlemen, there is a saying that if you want to go fast, go alone. But if you want to go far, take someone along with you. This journey has not been a one-man journey. This has been a collective journey. And there are very many people who have held my hand and have helped me at different stages. And I'm here to do one thing, say thank you. As you will appreciate, there is always a risk when you start mentioning names. And then you go back to bed and you say, oh my God, I forgot this person. So allow me say a thank you, a general thank you. However, there are people who it will definitely haunt me for the rest of my life if I didn't say and mention them in particular. So generally, I'm thanking everybody. But in particular, let me start in a special way by thanking the Dean, Faculty of Law, Professor Naruwairo. There was a time I met him at a function at LDC, and he told me, you have to do and finish your degree, your PhD. That was fatherly advice. So I want to thank him, but in a special way. Can we put our hands for the Deputy Dean? Dr. Nampeo is a special woman. One of the motivations was her leadership for me to choose and come here and do my PhD. Ladies and gentlemen, she is a leader. A leader is someone who motivates. A leader is someone who encourages. But above all, a leader is someone who guides. She did all that for me. I have a lot to say to you, but in the interest of time, I promise I'll bring my thank you card to you at an appropriate time. And thank you for chairing this session today. Next, and more importantly, my supervisors. Friends, I had good supervisors. I will start with Professor Bachivinga. Ladies and gentlemen, if there is somebody who is knowledgeable about taxation in Uganda, that person is none other than Professor Bachivinga. And with your permission, I know time is not on our side, but bear with me. These are people who have worked with me in this journey since 2022. Perhaps I will need the whole day to talk about them, but allow me to do that in a very brief way. Professor Bachivinga came to Uganda and was among the first people to head the URA. That was 1991 when URA had been established. The other people with him were expatriates from Ghana. He was the head of the legal services. He then decided to come and teach revenue law and taxation at Makerere University. That was in 1992, the following year. It so happened I was in my second year. Now you can tell my age. In 1992, I was a second-year student at Makerere Law School, called Faculty of Law. Professor Bachivinga decides to introduce a subject called revenue law and taxation. I thought about it, reflected, and decided that was the subject I was going to do. It was an elective subject, and remember at that time, as a student, you are interested in passing, and yet you are now taking up a subject that is taken on by very few people. In my class was Dr. Tsasirwe, who happens to be Dr. Tsasirwe was my classmate both at Faculty of Law and at LDC. So Professor Bachivinga taught me, I think we were very few doing the subject, but that's how I started the journey of revenue law and taxation. So we were the pioneers of taxation, courtesy of Professor Bachivinga. Fast forward, when it came to third year, then we were doing 3 years. When it came to third year, we are supposed to do a research paper. I had picked so much interest in taxation that I decided to do my research paper in taxation. And who was my supervisor? Professor Bachivinga. I graduate, I go to LDC, I start teaching taxation at LDC, and I decide to upgrade my studies. I had an option, like Dr. Karuhanga mentioned, of perhaps getting a scholarship and going abroad. But I always believed that I am researching about a subject called Uganda. And the best way to do that research is to do it here, especially if you have the resource. So I approached Professor Wachivinga and he accepted to supervise me for my master's, again in taxation. Where are we today? Professor Wachivinga is my supervisor for the PhD. Doctor of Laws. I can go on and on, Professor, but thank you very much. You've been a parent, you've been a mentor, you've been a guide. You've walked the journey with me, and I'm eternally grateful. Secondly, and more also importantly, is Professor Mbazira. Professor Mbazira is not here today. He is in Malawi, Lesotho. He's in Lesotho. He's advising the judiciary in Lesotho. And this is something that had been programmed many, many months back. So he couldn't be here with us, but Professor Mbazira, all I can describe him is that he's a very intelligent and brilliant man. But he's a good man. Many of you students who have gone through his hands will testify on how good Mr. Professor Mbazira is. Very simple, very approachable. But I want to thank him in his absence, and I hope I'll get an opportune time to say these words to him first.
He's online and he's listening.
He's online. Thank you. So, but I want to thank him. Professor Mbazira has been a great resource and has, remember, and I want to make this point clear. I was researching on taxation and its relationship to human rights. So I needed somebody who was good in taxation, but also somebody who was good in human rights. And none other than Professor Mbazira filled that post. So I thank him wholeheartedly. Quickly, I think I've said a lot about the professors. Quickly, let me go through the list of very important people who are here. The doctoral committee. I had a doctoral committee that was chaired by Professor Mayambala Kakunguru. I also had Dr. Nakai on that panel and Dr. Ismail Kintu. So I want to thank you very, very wholeheartedly for your guidance. I want to thank the panel. Ladies and gentlemen, it is not easy. When you sit in other doctoral defenses and you see what people go through, and now it is your turn. And when it comes to your turn, you see the best brains assemble in front of you. Dr. Ngabirano is a friend, but he has a Chinese wall. Dr. Ngabirano excelled, but more importantly, he is thorough at what he does. There is an American journal, Colin Powell, who once said that I cannot tell you the secret of success, but I can emphasize two things: preparation and hard work. Dr. Ngabirano prepares. If he's to do something, he prepares. And you can see from the kind of questions that he shot at me. Very thorough, very precise, and deep, I should say. Thank you very much. Mr. Festus Akunovera needs no introduction. Anybody who wants to find a good tax consultant, a good tax lawyer, should go and talk to Mr. Akunovera. As the chair introduced him, he's a first-class material. How many people get first classes at Makerere? You can count them.
We have one in the room right now, Alan.
Alan.
Yes, he's graduating with the first class.
Out of a list of how many?
280.
280, you have one.
Two. We have two.
You have two.
Yeah.
Out of 280, you have two first class. These are people who know what they are doing. And Mr. Kunovera Festus, when I saw you, I was like, yes, I have to prepare myself more. But thank you. Mr. Ismail Kintu, thank you very much. It's always good to have a blend. It's always good to, doctor. Maybe I should keep to the word doctor.
Dr. Hilda.
Let me keep to the doctor. Doctor, thank you. And your questions brought a diversity and of outlook. And I appreciate you for your time. I appreciate you for the question, and more importantly, for your guidance. My sister, when they say last and best, reserve best for last. I am reserving to tell you that I'm proud of you. I'm proud that despite your busy schedule, I know you have a busy schedule. I know that for a fact. But to make time and be here, thank you very much. I have noted all your comments. I've noted your guidance. I'll take every comment and address it before I hand in the final script. But thank you for your guidance. The registrar. Now that brings me to the administrative side. The registrar is about 6 months or a year, maybe a year or so. Here, I think having, but he has made my work very easy. Ladies and gentlemen, can we put our hands for the registrar? He has done one thing. He has changed certain things for good. The presentation was easy. I was able to see what I was presenting, courtesy of the registrar. But more importantly, the coordination. Thank you for coordinating everything. Thank you for handling us, even sometimes where you didn't have to do it, but you had to do it as a person who was interested in our success. Thank you very much. As I conclude, let me thank the lecturers who are here. At least Dr. Tusasirwe, like I said, was my classmate. Dr. Tusasirwe also got his PhD from Makerere. You need to go and read his thesis. Well written, well researched, and it was a good resource for me to have read through your work. And thank you for continuing to be a brother and a guide. As I conclude, I won't do justice if I don't thank my partners, especially the managing partner at Kampala Associated Advocates, my partners and the staff. Most of the staff are here today. They have been here with me. The firm allowed me to take off time and spend a lot of my work time in the library out doing research. Thank you very much, my partners. I don't take that for granted. Thank you very much, the staff of KAA who are here. I appreciate your support. But in a special way, Madam Chair, allow me 1 minute to talk about Dr. Karuhanga. Dr. Karuhanga is actually the brains behind KAA. He was the one who conceived the idea of KAA. And if I could talk about how brilliant Mr. Karuhanga was and his views, at that time, most law firms were using names, individuals' names. He came up with an idea of a generic name that will incorporate almost everybody. And that's how he came up with the name Kampala Associated Advocates. Dr. Karuhanga handpicked me. He encouraged me to join KAA as a founding partner with him. And Justice Katurebe, former Chief Justice, and Honorable Sam Mayanja, who's the Minister of Lands. The four, together eventually with Mr. Peter Kabasi, started KAA. But Dr. Karuhanga was the brains. I want to thank him. I think I will have time to meet him and once again thank him. But I want to thank him also for his kind words. the words that he mentioned while he was wrapping up. So, how do I end? The audience. I see faces here that have helped me in my work on a day-to-day basis. And that's where I fear mentioning names. Some of you are my respondents. Some of you were doing the research, gathering the data. Some of you were advising me. I see people from Ministry of Finance I met and discussed. I see people from some law firms like Max, people that I interacted with and gave me advice. I see friends, I see family. Thank you very, very much. My friends who are here, for you to come here from 2 and it's now coming to 7, and you are still here, I don't take that for granted. I don't take that for granted. Many of you have been here. Many of you have encouraged me. Many of you work and relate with me. I thank you wholeheartedly for your support, for your encouragement. Thank you. Lawyers were encouraged to keep using the word finally. And finally, I want to thank my family. And finally, I want to thank my family. Can I ask my family members who are here to stand up? Roger, all these, can you all stand up? There is someone missing. Okay. Yes, but this is my family. These are my people. These are people who held me, people who supported me financially. Yes, but thank you very much. I'm so grateful, and again, like I have said, I don't take this for granted. The staff who are here, the registry staff, the dean's secretary, I want to thank her personally. She was very instrumental. I know she's not here, but please pass my regards. And all the other staff that are here for a job well done. I've said a lot.
Congratulations.
Thank you very much. And may the good Lord bless you.
And it is Friday.
May his face shine upon you.
Amen.
And may he be gracious.
Amen.
For now and forever.
I think if Dr. Kambona is becoming a pastor. It is Friday, and I think we shall be able to celebrate with Oscar for those of you who will continue in the aftermath of the public defense. But Registrar, I think there are some logistical issues. Thank you once again for being with us this afternoon. It is a privilege for us to host you at the School of Law.
Thank you very much, Chair. Members, the examination is still on. At this moment, we are going to be taking a few pictures. We shall start with the candidate and the examination panel. And then after that picture, we shall be joined with actually, please, you can maybe, I think we can take from here. After that picture, it will be followed, the supervisor will join. Okay. Thank you. Dr. to be Kambona. Doctor, you can, thank you very much. Thank you very much. Thank you very much. At this moment, allow me also welcome the supervisor. Please, Professor Bakivinga, you can join the group photo. Yes, it will be followed by the family members. After this one, the family members, you can join. Yes, yes, you join them. You join them. The family members, please come forward. At this moment, allow me also to invite the faculty members to join. Do we have some faculty members around? They have left. Family members, please, you can come and join the group photo. You please. Yes. Family members, please join the group photo. Some of you can go the other side, please. Okay. And after this, I think some Okay, thank you. Thank you. I have seen some of you have volunteered to squat. After this photo, allow me to relieve, I will relieve the members of the examination panel and also the supervisor, and then the public can enjoy the photo moment with the candidate. Okay, thank you very much. The family members, you can say the public is joining.